Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
No gay commentary on the kid.
That's correct.
Dati mihi Anglican for his service. Oh, for Trump's sake. I didn't ask you to interrupt me.
Good morning, welcome to the Court of Public Opinion. I'm the Recovery Addict. Thank you very much for joining me this wonderful, wonderful Wednesday morning. It is good to be here. It seems like we were just here though. It seems like I only got a little bit of sleep. Why was that? Oh wow, what a day, We had a late night. I think it's the latest verdict we've ever had on the channel in the Ashley Benefield trial. It surprised me, didn't surprise a lot of you. I was wrong yet again. But wow, what a day. It was whirlwind, crazy. Have to say a big shout out and a thank you to there we go, Sienna's Baka, our grandma. Sienna's grandma. Thank you very much. First in chat, Sienna's grandma. I'm pretty sure this is your first time. This is a first offense for you. You've never been first in chat before, according to my records. And now my records are not perfect, and I do make mistakes. But first in chat, I'm not sure if you know this, but first in chat there's a prize, but it's also sort of a punishment. And so what we're going to do is we're going to sentence you to punish you for being first in chat, and we're going to assign you internet ownership. We're going to gift the entire internet to you, but it's not like something you can sell. No, it's something you have to maintain, and then it gets passed on to somebody else. So you're responsible for everyone's internet problems worldwide today. And somebody does this every day, and today that somebody is you. So thank you for taking one for the team, Sienna's grandma, and love that you're here first in chat. Thank you very much. Make sure you head over to the shopping page. If you scroll around in there far enough, you'll see that there is a certificate of internet ownership, which you can download for the low fine of 50 cents. It's fill in the blank. It's pre-signed. And anyway, congratulations. Yes. You say number two. Number two. What? I show number one. How did you? I show you're number one on my list. I'm just saying. If I missed it and it was somebody else, let me know. But thank you. It's your second time. Thank you for admitting to a prior offense. Unlike court cases or on trial, civil or criminal, prior offenses are not going to hurt you in this case. The sentence is still the same. It's also not going to help you. All that shows is that we might have a repeat offender on our hands, and we love that. So thank you for being here first. Love it. All right. A couple of you are saying, what? Wait, there was a verdict? Yep, there was. And it was so late that I've never seen this before. The judge said, I'm going to let them debate or deliberate until they ask to go home. He didn't tell them they have to ask to go home. He said, I'm going to let them deliberate until they ask to go home. They did have two questions. The first question was about evidence. Judge couldn't help them. Second question was, we're hung. To which the judge responded after consulting with the lawyers, do you want to go home for the night and come back tomorrow? And the third answer we got from them was, nope, we'll stay. And then they came out with a verdict. And wow, what a verdict. Just amazing. I did not get much sleep last night, but we're okay. We're good. I did run to the post office. Oh my goodness. I've got 1 quarter-size skeleton model, which we are going to be using in court cases now as well with the Gumby to illustrate injuries and things like that. Thank you very much for that. I've got some hand tools for when I can't talk but need to answer questions. A little no, yes. So we've got some paddles there that we can help answer questions that way. I have a secret stash of caffeine that is in the fridge right now, and we got a very thoughtful gift for from a very thoughtful member of the community here for my wife's sister, who we're going to be going to visit, who yesterday morning had the C-section to deliver her baby that had passed away, and just thank you so much for the thoughts and prayers for her and her family. We appreciate that, and we're super excited to carry that gift as sort of a representation of all the concern and love that's been shown for us through us for her. Thank you very much. That being said, don't send any more because we have very, very limited space. Our car is full, so we can't pack much more. All right, let's see. I'm trying to see. Let's see. I think there were a couple messages. BG gifted a membership. Thank you very much, BG. And BG gifted another membership, or maybe it just came through twice. I don't know. Thank you for the gifted memberships. I have to do one thing before we go too far.
Mike. What day is it, Mike?
Yes.
Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. It wasn't the longest, but I'm a little got a little lightheaded there for a minute. The effort was high. The quality was not the best, but the effort was high. So hopefully that scored some points with my child who's currently still up for adoption. BG says, whatever equipment you're after, love you. Thank you very much, BG. We are putting that together right now. I'm in my spare time. We're putting the order to replace this things because we're still having problems. Some things are working intermittently, some things are not, and I've just got my fingers crossed, and I'm not going to bump it. I've been turning it off, letting it cool down all night, which I've never done before. Apparently, that might help. But also, in the replacement, I found a company that will sell me the replacement and give us a 2-year warranty on it, which the company, it's not factory, it's just the store itself. They'll just replace it if it breaks. So, yes, that's what we're going to be doing. We're putting that together. I'm not sure if we'll have it before or after we leave on our trip, but it'll be, someone's been practicing. Thank you very much. We have a day and a half in store. Sorry, you guys were not ready for hump day. My first hump day shout out with earbuds, says Catherine. Welcome. It's like a baptism by fire. You're now one of us. Once you've had your ears rung by the hump day yell, that's officially, you're now a member. Let's see. JC responded to her emotions. Oh my goodness, that's gonna be wild. Lenova, thank you very much. Lenova is I call her my stock broker advisor. She sends me stock tips in the way of a tiny portion of stock, and I don't say tiny because it's too small. No, it's huge. She gifts a ton of these, and she's like, "Oh, here's one you should follow," and she gifts me the stock so that I can follow it on CashApp. So Lenova is my stock broker. Thank you very much. Oh my goodness. So just for information. Looks like Amazon, Sprouts Farmer, Garmin, and Transocean. There we go. Thank you very much. I will start watching those and invest accordingly. Not necessarily. You shouldn't. I'm not giving you any financial advice today, just so you know. So much for not eating after 8 p.m. Okay, I will tell you, I did eat after 8 p.m. I did stay up later because I didn't want to sleep on a full stomach. So I stayed up till 1. I stayed up till 1 last night and, got some things done that we needed to, did some shopping, relaxed a little bit, just decompressed after what happened Let's see. Oh, birthdays. Oh my goodness. We have so much to do because the court case is about to begin. We've got to sing quickly. We have the Bad Apple River trial sentencing that's happening this morning. Following that, we might do a tiny bit of court hopping, and then I think we've got a case we want to follow that will be in Judge Boyd's courtroom today. It's a murder trial. I believe it's a vehicle accident situation. So we're gonna follow that, and I'm not sure if it was entirely accidental or on purpose. We'll find out details once that court starts. So that, fingers crossed for that. If everything works out well, that would be great. Birthday song. Here we go. Warm up with me. La 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 la. There we go. We're gonna sing to Darlene and Hayes. Hayes is a dog, but dog's listening. Both celebrating their special day. Wonderful, wonderful. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Darlene. And who's a good boy? Hayes. Happy birthday to you. Darlene and Hayes, it's your special day. I have to say, this one, we have to give it a little sort of different advice. Darlene, help yourself to free pancakes. Hayes, we've got treats for you all day long, bud. All day long. Happy birthday. We're so excited to celebrate all the birthdays that happen year long. If you have a birthday that happens, let us know. We'll sing to you. We tried to do it at the beginning of the show, but Nova giving birthday cake as well. Woof, woof. There we go. Woof, woof for the dog. It says Smellatary. Have a happy birthday. I realize there are a million places you could be, a million people you could celebrate with. You've chosen to be here with us, or in Hayes' case, your owner chose to be with us. So thank you so much. Hopefully we can make your day a little more special. We have dancers and everything. I enjoy that everyone sings together. What a way to start the day. Singing to somebody else. You can't have a bad day when you sing to somebody else, especially happy birthday, and knowing that somebody out there, this is their day. Thank you. Thanks for sharing it with us. I think we have to... I'll try to keep it going until the drum solo. But we're about to jump into court in the Bad Apple River stabbing sentencing, which is it's been a long time. It seems like it's been 2 months. Is that right? Maybe more. 2 or 3 months ago we had the court case. Still cleaning grease off the equipment. Oh, that pizza was so good. That pizza was. Both my German Shepherds, BG says, when you said, who's a good boy, and woof woof, both my German Shepherds stopped and looked at the TV like, what the heck? That's awesome. I think we have a drum solo here. Are we ready? Next verse, last verse. We've got the drumsticks ready. Yep, that's the tap, 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 tap. That's our cue. Here we go. Everybody ready? Big finish. Beautiful, beautiful. Happy birthday. Thank you very much. Have a wonderful, wonderful birthday. I hope I didn't miss any. I didn't see any other birthdays come across while we were singing, so thank you. All right, we are, back up to the Apple River. I can't even remember what state we're in, Britta. What state's the Apple River in? This for those that recall, no, I'm not spoiling. I'm not talking about the verdict. I know a couple people want to go back and watch that, so I'm going to try to just let people do that. It was our very last live stream. It's pretty quick. You know it starts and we got all the verdict song in, which is great. Wisconsin, thank you, Wisconsin. I saw that a million times. Donnie's like, Alaska? I don't think they have apple trees in Alaska. The moose would just eat them. I'm not going to spoil, so we're not going to talk about the verdict right now because a couple of people might want to jump and watch that. It was worth the watch for sure. If you want to go back and watch that, if you missed that, it's not too long. In this case, the Nikolai, I think we call him Nikolai Mew. This is the case of the families that were floating down the river and the kids that were floating down the river, and there was some sort of altercation, and Nikolai Mew he sort of did the run up to them and held onto the tubes, and it ended in a stabbing, and it was terrible because everyone's running cell phones because they're all having fun and partying, and then this weird thing happens and people are filming, and we had 2 very graphic injuries there. He was convicted. Now there has been a PSI, and now we're going to find out what the verdict is right now. So there are no snakes in Alaska? Is that true? Yes, for the culture. Oh my goodness. Yes, we've got the video for the culture. It seems Evangeline Light. Thank you, by the way. Evangeline Light paid for pizza last night. Thank you. It was delicious. I did weigh myself. I'm up about half a pound from where I was yesterday. But that's all cool. I'm good with that. Nikolai Mew. The PSI. I remember when they said when they were going to have the sentence. I'm like, wow, that's way out there. That seems a little bit longer than normal. A lot of times we'll see a PSI that takes a couple weeks to a month, or maybe 2 months. This one was 3 months, and it was good. What kind of pizza? We went with Pizza Hut. I had the 5 meat because I wanted the healthy one, right? And meat's healthy, I think. It's definitely greasy. It was really good. Yeah, we'll be good. So I do weigh myself every morning and every night. But I don't worry about it. What happens is my scale, you have to sort of stand on it for a minute before it registers. It's like, and so I get on, and if it's not a good number, I just get off again. And it never registers and never sends it to my phone. And so I might not have a check-in on my app until I'm back on track. So my check-ins on my app show my weight dropping, even though there are times when it was up and down, up and down, up and down. So that's my compromise. All right. Vegetables are healthy. The boys chose. That's the thing. They chose. I've heard it's not good to weigh yourself all the time, but I honestly I can't stress this enough. I don't really care what it is. It's like it's up, it's down. It is what it is. But it's next to my bed. Like I step off my bed and I land on the scale. And when I get into bed, that's the last thing I step on. It's just part of my routine, and I love it. So, I don't do it. What difference does it make? That's my question. I mean, your body goes in cycles and weight goes up and down, but knowing where it's at different times, it just gives me more information. I'm actually more comfortable knowing the fact that, yeah, I'm up 2 pounds right now. That's fine. I'll be down later. You know, it changes. I'm really good. I'm really comfortable and not. I don't let it have any like influence on my day or anything else, but it doesn't harm me at all. That's what I'm trying to say, Jojo. If I was up 20 pounds again, that might hurt a little bit. But having lost more than 20 pounds, I'm like, hey, I am so happy with where I'm at. All right, so in moments, we should be getting a feed from court. I don't have it yet, so as soon as that's available, we'll bring that to you. I know I'm losing inches because I've had to tighten the belt, and that's a good feeling because up until then I was just buying bigger belts, and now getting to tighten the belts, and maybe some of my old belts might fit again. I'm super excited about that. Dale, member for 14 months, says, wait, what? I've been sitting on my couch for 14 months? I'm good with that because I love it here. Dale, that's awesome. That is awesome. Let's see. I went to the post office today. Thank you very much. And we got some really thoughtful and some fun gifts. And thank you. I am going to be away. We're basically packing up everything we own and leaving. At least I'm packing up all my equipment. I think I can count on one hand the pieces of equipment I'm not taking with me. So my whole studio is going to be going, except for that TV, which is on the fritz. But thank you. Oatmeal for breakfast. Oh, it's hot. Thanks. So they're going to hold my mail. The post office box is fine. We're going to hold the mail at the house as well. So if you send something now, just know I might not get it for a month or so. I'm going to do a little bit of brown sugar this morning on my oatmeal because I've been a good boy and I deserve it. My son's like, no, you aren't. Taking that back. Thank you. All right. they are going to do the thing for me. It's great. Let's see. Did you by chance get a couple stickers in the mail? Not yet. Not yet, Bug Dugger. The last sticker I got was from Red Pen, which we're going to stick on our new audio box because it has lots of places for stickers. Midlife Mania. I say I'm going to be gone, but I'm going to be here. I will be Monday and Tuesday. I will be driving next week, Monday and Tuesday. But after that, it's just the show is normal. It's just I'll be in a different studio, so there will be almost no changes except for we will be in person at the Corey Richens trial for the 2 hearings that happen in August. Other than that, I'll be here with you all, and my family's going to be off on vacation. I'm working; they're on vacation. That's how it works. I don't think I'm taking a green screen. Not planning on taking a green screen, which will actually save me one piece of equipment. Yes, we have a road trip. I will be checking in from the road. What about feeding your cat? We have a neighbor, a great neighbor, who's very close. By very close, I mean he's within. I think they were about a mile of us, and we swap. When they leave, we feed their cat, and when we leave, they feed our cat. So we've got that covered. We're good. We're good that way. Teresa, I will say my family has, I don't want to go into a ton of it. We have a lot of allergies. I would probably say we're pretty cautious about that. So probably not, if that's all right. I don't mean to offend at all, but probably not any home canned food. We're just very cautious that way. And I'm not saying you. I mean, you could say, "Oh, there's nothing in it." That's fine. It's just we've had some close calls with allergic reactions. So, Creative B says that means I can get something done around the house on Tuesday or Wednesday. That would be great. Don't forget to stop at Buc-ee's. I don't know if we're passing any Buc-ee's. We're going to be on I-70, so we're swinging from North Carolina up to I-70. I think we're joining. But does it go up around near Cincinnati or something? So we're going pretty high north. It adds 15 minutes to our trip. I kid you not. It's between that and swinging down through Tennessee, there's a 15-minute difference overall. So we really have a lot of options. So we're going to be swinging north. But sadly, our trip is planned like down to the minute. And I won't be able to make like stops along the way and see people. I know we'll be driving through, we're driving through a couple people's towns that are like, hey, that's right where I am. I don't believe I'll be able to make any stops. We just, with 5 kids in the car, and it's only going to be 5, not 6. My oldest decided not to fly out and then drive back with us. We're driving for 4 days, and it's going to be sort of exhausting. We'll be smelly, stinky, and grouchy, and I'm not sure he wanted to meet with us in that condition. But so long drive. We are super excited. Let me just say, as we're waiting for court to start, because we've got a minute here. I've never in my life been able to take a vacation like this, and I'm not really taking a vacation. I'm still going to be working. I'm just driving them there and then driving them back. But we've never been in a position where we can take a vacation, and we have lived out here in North Carolina for 5 years and haven't seen our family during that time, with the exception of a couple siblings that were able to come visit us. And we miss them terribly. And so we were super excited to be able to go back and coordinate, mix that with the court case that's going on and sort of make it a dual purpose trip. I'm super excited. You guys have made it possible, honestly. Not just with the equipment, which you guys have supported me in super ways, but you guys have made it possible for us to do this, and we love going back. It does coincide with just some things that are happening with the family that we really want to be there for, to support people. So it's good. Why do I have this image of Recovery Addict in a huge RV truck while towing a portable studio, Mike? I wish some of those portable studios and the RV would be awesome, but no, we're going to be in a cram-packed full Suburban with a trailer hitch cargo. which we're probably going to get pulled over for. I'm guessing, I'm pretty sure it's illegal to cover your back license plate. And North Carolina only gives you one license plate. We don't do front plates here. And so every time we go through a state with no license plate on the front, we're probably going to get pulled over because we have luggage covering our back license plate. Quick call this morning. Let's see who's on the phone. If it works. Oh. It's trying to connect. Call failed. Sorry. It tried. I tried. I have been to Buc-ee's twice. I actually have a Buc-ee the squirrel right here next to me with our puppets, hand puppets. The trial we're watching today, I haven't even made a thumbnail. Our amazing mods found this for us and confirmed that the case was happening with Boyd today. Let's see. Hang on 1 second.
Call from Lego My Briefs.
Lego My Briefs, good morning. How are you doing this Wednesday?
Good.
Happy
I'm
hump day.
doing good. Happy hump day to you as well. I watched, this is very quick, I watched an interview with the Stabby Rivers brother. Mm-hmm. And I remember at the end of that trial, I thought he did it. I thought he was very vengeful. We all had differing opinions. Mm-hmm. However, when I watched this interview and I heard about his upbringing and stuff like that, I ended it thinking, the poor guy. Anyway, so I tried to find it this morning so I could send it to you, and I just can't seem to, maybe because I'm rushing, but it's something for us to look at, this short interview. It would be fun to watch.
That's we may we've got we're planning on doing some court hopping, so we might hit Judge Cedric. Yep. We definitely have a trial with Judge Boyd this afternoon, which we'd like. It might be a 2-day or more. We'll see how long it takes.
Okay, good.
But yeah, it's interesting. I remember at the Bad Apple River trial, we did have some mixed feelings, and it was a mixed group on the results.
Yeah, very mixed, and I was the one who was adamant that he did it on purpose, but the
jury agreed, and that's
and the jury agreed.
One thing I'll do is I'll stand by the jury. The jury made a decision.
100%. Me too. Yeah,
I'll say.
But when I saw that interview with his brother, it just gives you an insight on how he was raised, and it kind of makes sense that he flipped. I don't know. That's the way I felt, and I thought, this is interesting. I wonder if anybody else has seen it. So it's something to look for. I just couldn't find it this morning. So
yeah, I haven't seen it. We might have to watch for it. I probably won't be able to watch it today. But
some
of those interviews
are
very difficult for the channel to watch for legal reasons.
Right.
So
right. Okay. Good. Happy hump day.
Thank you very much. Halfway through the work week.
Have a great afternoon.
You too.
You too. Bye.
Let me say this about the verdict. I've been wrong probably, I think about 75% of the time, which I say, I think I'm leaning this way and the jury goes the other way. About 3/4 of the time they vote opposite me. So take that into account on future cases. But I have so much respect and belief in this system. It's not perfect, right? It is flawed. It has its problems. But the system itself is something I have not seen a better one out there for trying someone criminally in court and giving them an opportunity and having a fair chance at defense. It's the best system I've seen, and because of that, I believe in it. I support it. And when the jury comes back with a verdict that I didn't agree with, I have to respect that and respect the system and respect the work that the jurors did. And that's what I do. So we try to honor that as good as possible. Selena gifted a membership this morning. Thank you very much, Selena. I think I will get the chance to meet Selena because she's going to be in the same courtroom that I'm going to be in for Corey Richens, right? Selena, are you planning on making a trip there? What time does the hearing start? It's supposed to start in right now, but we're waiting still. Weren't they late often during trial? I think the Apple River trial was one that was always late. Nikki says she's seen the interview that Lego was talking about. It was a great video to get some background on him and how he was raised and what he went through growing up. Some of that might be coming in. If we have victim impact statements, during this hearing. We might get some from the family as well. Let's see. Good morning from Thousand Islands, New York. Oh my goodness. There was a time, Darlene, as a kid, where I thought, when I grow up, I'm going to buy an island. Because I was shopping for islands. I kid you not. As a child, I was signing up for real estate brochures and advertisements for islands around the world. Caribbean, you name it, Alaska. When I thought I want to buy an island. That dream has moved out of my price range so far. It's not even funny. But the idea of spending some time on an island appeals to me, especially if I can fish from like my back porch. Diane says, after being a juror twice, I would never want my peers deciding my fate. That is something I don't think we've watched at all on this channel. We've never watched a deep dive into the deliberation that happens. Most juries keep that secret. That there's even the jurors that go out and talk generally don't spill everything, and a few that have we haven't covered on this case, or on this channel. Let's see. Two words about watching the video. Doesn't the fair use thing cover you? Fair use is really tricky. It's really, really tricky.
Call from.
I talked over your name. I talked over your name. Who is it on the phone?
Christina.
Christina, how are you doing?
Yes.
Good morning.
I'm good. How are you?
I am doing absolutely fabulous.
Good. So I'm content of 1979 on the YouTubes. But the only reason why I'm calling is because I've got to give a shout out to all my cheesehead Wisconsinites that are out there, because there's a lot of us.
There are. Some great
Yes.
friends of the channel up there as well. Yep.
Yes, we are many and we are friendly. I'm just saying.
And you have cheese. I mean, what's not to love about that?
Tons of cheese.
So tell me this.
You know, I will say that if you ask a Spaniard, they will tell you our cheese sucks, but that's wrong. That's not correct.
They're incorrect.
So don't ask a Spaniard.
What is the cheese, like the right cheese for Wisconsin? Is it like a cheddar? Is it Swiss? Is it what cheese do you guys like?
I would be honest with you. I think that depends on taste, because I'll eat just about any cheese. But right now, if you look in my fridge, you would see I have Swiss, I have a Mexican blend, I have Colby Jack.
Do you buy it by the wheel? Do you have a whole cheese wheel? And just cut off what you need?
I have, you know, honestly, I haven't. So I live in southern Wisconsin, and I go to Prairie du Chien, which means absolutely nothing to you. But on the way up there, it's about like a 2.5 hour, 3 hour drive. On the way up, there's a factory. It's a cheese factory, and you can buy the chunks, like big chunks, you can buy like the butts and ends. And so I like to get the butts and ends because you get it cheaper. And then I freeze it. So, cheese butts. Yes,
nice.
Exactly.
I do love a good crumble cheese. I like cheese curds. There were cheese curds. There was a factory. I think there were cheddar cheese curds growing up, and we called it squeaky cheese because you'd bite it, it would make this. It would squeak.
Yes. If you leave it out, it'll squeak in your mouth. Yes. Those are real cheese curds. Those are the good cheese curds. You leave them out, and when you chomp on them, you can literally hear them squeak. Oh, they're so good. I'm
gonna say something that is probably heresy, and you might unfollow me for this, but I'm also a big fan of Velveeta. I'm sorry. I know it's practically plastic.
That would be my husband too, and I'm like, that's oil, but whatever. I guess each person. He's from Illinois too, so I mean, there's that. I will say, when you come back from your trip, they do ship cheese curds from Monroe, which is close to where I'm from, and they're fantastic cheese curds. So when you come back from your little trippy trip, maybe we can set up some cheese curd delivery so that you can try some really, really good cheese curds.
My diet's going to just go down the drain on this trip. I am planning. There are some factories, literally. There are sweets factories that we're planning on visiting, particularly Well, Pepperidge Farm Factory, which makes crackers, the goldfish crackers. We love going up there. They have so many yummy foods. There's also a factory that makes something called a creamy. A creamy is imagine like a ice cream popsicle, yogurt popsicle. They have flavors that would blow your mind, and they are so good. And we're going to be right up next to them. I think last time we went there, I think we spent $140 buying creamies in bulk. We had coolers full of creamies, and this was because we knew we were moving away. And we just bought tons and tons.
So is it like a frozen treat, or is
it's on popsicle on a stick.
Okay.
But I mean, they have amazing eggnog. I mean, delicious. The eggnog ones were unbelievable. I actually went to school with the chief financial officer of the company, and he was also involved on the board for making flavors. And he'd propose a flavor, and their recipe guys would go out and make one and give them samples, and he'd bring us samples of ones that have never been sold before. He's like, "Hey, can you guys be our test gummies?" He's bringing in like thousands of creamies, and we're just eating them in class. It was so good. I don't know what he taught, what the lesson was, but we ate a lot of creamies in that college class.
I don't know if you caught yesterday, but we were talking about when the food chat was going on, we were talking about liquid potatoes and liquid grapes and all that stuff. And, eggnog with liquid potatoes, if you're following my thought process there. And that's pretty good. I'm just saying.
Wow. That's, I love it. I'm looking forward to some cheese. The Cache Valley cheese is something I grew up with as a kid, living up near the Utah-Idaho border, and absolutely love that. So let's hear it for cheese. Mrs. R.A., fun fact. Mrs. R.A., there was a time when we were quite poor. I'll say that, where date night meant we went to the grocery store and bought the food for the family. That was all we had money to do. And so for date night, what we would do is we would go to the cheese section, and we'd choose one of those where they have those little slivers of different flavors, and we'd just try a different cheese, and that was our date every week.
Oh, fun.
We'd choose a cheese, we'd take turns, and we had some amazing ones and some that were like, maybe not this one again, but it's funny that we have cheese in our relationship.
Making the best of the situation.
Yep, it's great memories. So
let me just tell you though, on vacation, calories don't count. So don't let that get in the way of a good time, all right?
I will not
when
let
you
it get
get back, you can recenter and refocus and get back on track. But don't stop from enjoying the things that you used to enjoy just because you want to lose weight, because it'll happen again. Yeah. And you can refocus. That's my opinion.
I've made some changes in how I eat that I think, even though I will try, I'll eat some food that I probably are not good for me as far as calories go and all that. But the amount I eat has made a huge difference in my life, and I think I'm going to stick with that, even if I try a whole bunch of yummy
for
food.
sure.
So
anyway. You can eat in smaller portions. But anyways, I'm sorry. I just wanted to say hi to everybody. So I'm
thank
sorry.
you.
I'm a chit chatter.
Hello to everyone in Wisconsin. Thank you.
Yes. Thank you. Have a good one.
You too. We'll see you. Bye.
Thanks. Bye.
All right. Still nothing from court yet. They are running late. Christiane says, "What a wonderful 9 months. I love every single one of you. All right. Thank you for all you do for us. And all we don't do, right? And all we don't do." Ella Cole says, "Is Mrs. R.A. driving in a separate vehicle for this trip?" No, because it sounds like the only way to remain a happy family in this case, 4 days praying for you all. Nutters. Very much. We have never done a road trip like this. I mean, Ella, the furthest we've gone in a day has been about 6 hours. I've done a road trip. I love driving. I used to drive. I was a regional sales manager. I used to drive, 36 to 4,000 miles a month, and I loved it. I love being on the road. I love driving. I'd like to think I'm good at it, but my wife might tell you differently. But so I'm happy to do that. But being in a car with a lot of people, we've got a lot of ideas and games, and luckily we've got some kids that absolutely cannot get car sick even if you tried. So those will be reading books. We've got some devices to watch. We've got some. The car we bought has a video player thing on the roof, a DVD player. So we've got some videos that will keep them entertained a little bit. We've got some audiobooks to listen to. Are we there yet? Yes, I see. Teresa, I see this. We're going to get a little bit of that. We also have a map. We have a bingo game that we're going to be playing with items that my wife's done research about, things that we're going to see along the way. In some places we're going to plan stop. We have planned stops at least every 2 hours, like a giant pitchfork and things like that. Anyway, we're waiting. How much longer? How much longer till we start court? They're late. They're late. We're waiting for the feed. It's not going yet. How many kids in the car? 5. 7 total. I've taken the time difference into account. I think we're good. They should be starting any minute now. But we'll keep talking until they do. The alphabet game, we've got that. We've got bingo. We have we love doing audiobooks, and it's fun because we've kids ranging from early 20s to 9, right? Which is a fairly widespread. My 9-year-old was standing in the post office with this morning, and he has a conversation. He says, "I'm serious, and this isn't theoretical." So our kids have a vocabulary that's pretty good, so we can listen to a book that the 20 plus year olds enjoy, and the 9-year-old still gets a lot out of it. So that's going to help us a ton. Yes, we won't skip the breaks. I think, Jojo, honestly, it's going to be more healthy for me driving than I am every day here sitting in my chair. One girl, Kelly. We've got a basketball team and a cheerleader, is what we like to say. So, Andrea, the court's not allowing camera or recordings of victim impact statements. They're on the second victim statement now. Andrea, thank you. That explains why they're late. So we might not get to see most of what we were hoping to see. We leave this weekend, so we don't have a podcast tomorrow because Thomas is doing a road trip of his own, and we leave this weekend. We're really excited, really excited. Apparently, the court has not allowed the victim statements to be televised, so we might court hop just briefly while we wait for them to come in. Britt Bottoms, I got 4 packages today. We got a very thoughtful gift for my wife's sister. We got a skeleton model that we can be using for demonstrations and injury demonstrations, things like that. We got some signs that I can hold up to say yes and no when I can't talk during court and we're listening to something quietly and still answering questions. And we also got a little secret stash of caffeine, which I might have just on reserve for the trip in case I get a little sleepy and need to make it to the next rest stop. Age difference is wild. Yes, we've got a fairly wide spread. Yep, Britt Bottoms, thank you very much. Love it. Perfect. That was perfect. There is going to be a live stream from you, but apparently these victim statements have not been allowed to be filmed. So we're waiting for the feed to come in. It might just be the sentencing at the end. So fingers crossed. I think we're on the second victim right now. No camera for victim impact. I'm headed out to court out west. We're going to be in. My son's getting married in Idaho, so we're going to be out there. But I'll be in Utah and Idaho because Utah has a court case that we'll be following. And there are going to be 2 hearings in August. I'll be there for. And that's the Corey Richens trial. That's going to be up there in Park City, the same place we watched the ski trial with Gwyneth Paltrow. Lori, I would say it's not common to not have audio or video. This is a bit much. Normally, I've seen the judge say don't show the people talking, but usually the audio is carried. Christina Ricci trial, they got busted for mics picking up lawyers' tables, so they're down for the moment. Oh, man. Guys. Chrissy Bacon, I love your last name, by the way, says congrats on the 20-pound loss. You have a healthy attitude about it. Love this channel and awesome peeps here. Thank you for the kind words, Chrissy. I appreciate that. Chris Wallace says, love this place. Greeners donated to the Island Fund. Oh, my goodness, Greeners. Thank you very much. Selena K gifted membership. Thank you, Selena. Ken Ginger, member for 5 months. Auntie Candy, half pound has the overcooked, undercooked rice. Not a yes. Blame the rice. 100%. I'm with you on that one. On the phone with us, joining us now, one of our great moderators. Amber, how are you doing this morning? Happy hump day.
Hi, I'm good. Happy hump day. Happy birthday to everybody that had a birthday. I'm talking really fast. I know. I'm sorry. I just got word that there was a second ex parte meeting that defense was just handed a transcript of yesterday in Young Thug's case. So stay tuned for a second ex parte transcript between the judge and prosecutors in the Young Thug case.
That's going to be good.
That apparently has had several defense attorneys had steam coming off their bald heads all night.
Wow.
According to the defense attorney's argument. I just got really excited because there's another ex parte transcript that nobody knew about.
I've never been more interested in the happenings of a case without having any interest in the actual charges and evidence of a case as a young thug. I have zero desire to watch the case for the actual crime and defense side of it.
Same. Total same. I have no idea what's going on with this case, with the facts of the case, but the judicial conduct
there's a lot.
What I would call it.
There's a lot.
Yeah, that it's all very curious to me.
Yeah. We'll watch for that.
And I like airing stuff out that needs to be aired out.
I tell you, corruption, a good cure for corruption and bad behavior is sunlight and putting it out in public. So,
right.
When you see the transcript dropped, let me know. We might read that, depending on how long it is.
I certainly will. I'm waiting for it to drop. I keep hitting the refresh button like a fiend. But I also kind of bring these instances up when these are things that we don't usually see very often at all. Like it's not something that happens in this type of case all the time. No, this is conduct that we don't see, much less hear about. And if we do, we definitely don't get this much detail and see the process play out like we are with this. So I just think it's neat to see how the process is supposed to work.
Apparently it was 3 days before the one we knew about.
Yep.
And they never mentioned it.
Nope. The judge handed the defense attorneys a stack of papers at yesterday's hearing. I guess at the end of that hearing, and it was another ex parte transcript from, I think that was the 7th.
She's like, oh, by the way, this happened. Okay, see you guys tomorrow.
Right. So that would be, I just put that together. So the 10th was after Woody had testified and took the fifth on the stand. So the 7th is that same day he testified for the first time and took the fifth on the stand. It was that same day.
This is going to be juicy. This might have more in it than the one we read already.
Oh, I'm excited. So I'll let you know when I have that pulled.
It says transcript is available, so good luck. Let me know. So.
Yep, I'll let you know.
All right.
But have a good hump day, everybody.
Thank you, Amber. We'll see you. That is, yeah, that's going to be fun. I don't care about Young Thug in the least. That the case, I've said this, the case does not interest me, other than the fact that it's a RICO case. It doesn't interest me. But the happenings in court and the back and forth, the legal side, I am very interested in. It's from the prosecutor's initial contact with the judge, asking for the meeting, supposedly. Yeah. Still nothing. We've got audio. As soon as the audio comes in from court from Nicholas Mew sentencing, we'll have that. But I haven't finished my oatmeal yet. Let's see. Someone asked how I lost 20 pounds. Mostly, I would say mostly it's been portion control, and I basically cut sodas out of my life, with very, very few exceptions. Sodas used to be my go-to. It's on the menu for today. Oatmeal. Oatmeal in the morning. I don't know what's for lunch. Probably a salad. It's in Modjet. It just dropped. Oop, boom, 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 boom. Supplement is 19 pages. Do we want to start reading this while we wait for Nicholas Mew sentencing? Then we'll cut to it as soon as the audio comes in. Let's see if we can do this. Bing. You've got mail. There it is. All right. This is a supplement to DeMonte Kendrick's motion for mistrial. Is that the right one? I think that's it. Do I meal prep or plan your meals? No, it's just portion control. And I eat the same food I ate before. Although, with the exception of salad. I've switched to eating salad every day. I guess so I made a huge change. Changed my diet, but I've always loved salad. It's just, Mrs. R.A. and I just decided we're going to make sure we have fixings for salad all the time. I have salad dressing. I don't even go skimp on the salad dressing. I just eat salad instead of quick, greasy food. That's the one that dropped 8 minutes ago. Okay, we've got a little, while we wait for court to start, and you'll hear the audio just burst in when it does happen. So we'll jump back to the Apple River trial as soon as that's ready. But right now we have this motion. I need to move my oatmeal. State of Georgia versus DeMonte Kendrick. Supplement to DeMonte Kendrick's motion for mistrial comes now. DeMonte Kendrick, petitioner by and through the undersigned counsels, and brings this supplement to motion for mistrial showing as follows. Outside agitator is a term that delegitimizes, never seen that word before, internal dissent against the status quo. So anyone who speaks up against the status quo, whatever it is by definition an outsider. He starts with a quote from a professor from UC Berkeley. Judge Glanville making outrageous allegations against members of the defense teams in the present case, but I think it does in some way outside agitators and everybody else who I think are trying to influence. The third ground argued in... What is this? It's not... I don't think this is written very well. Third ground argued in Kendrick's motion for mistrial is that Kendrick's due process rights were violated relating to 14th Amendment due process violation relating in part to Chief Judge Glanville wrongfully coercing Copeland to testify. Further evidence of the state and the Judge Glanville's violation of Kendrick's due process rights has just come to light. Yesterday, after court, Kendrick received a rough transcript, Exhibit A, of an additional secret ex parte meeting with Judge Glanville held on Friday, June 7th, 2024. The rough transcript was helpfully provided by this court to defense counsel. A reading of the rough transcript highlights that it has been obvious to all observers except for Kendrick's counsel for the last 19 months. Judge Glanville has been willfully biased and acting as a member of the prosecution team since the inception of this case. Kendrick's counsel takes no pleasure in alerting this honorable court to the situation, but client obligations require it. Due process requires a fair trial. It is not a fair trial when an ex parte meeting, Glanville, Love, Hilton gossip like Yannetta's over 13 pages of transcript about attorneys Shart, Melnick, and Steele. It is not a fair trial when in an ex parte meeting, Glanville, Love, and Hilton assassinate the character of attorney Melnick and attack his integrity, alleging that he is not acting in the best interest of his client, Copeland. It's not a fair trial when in an ex parte meeting, Glanville, Love, and Hilton attack attorney Bumpus for allegedly hugging Kendrick and stating that she is incapable of representing Copeland. It's not a fair trial when in an ex parte meeting, Love lies to Glanville about an email she received from attorney Melnick. It's not a fair trial when in an ex parte meeting, Glanville starts talking about outside agitators, stating, my comments today were predicted there's a lot of stuff that's going on in the background, but it shouldn't have anything to do with y'all's case. It really shouldn't, but I think it does in some way, outside agitators. It's not a fair trial when an ex parte meeting, Glanville and Love have the following outrageous conversation, court. But I think it does in some way, outside agitators, Mrs. Love, that too, the court. And everybody else, I think, are trying to influence Mrs. Love. That is absolutely happening. That's a rough transcript. It's not a fair trial when Glanville, Love, and Hilton have this further discussion. Miss Hilton saying, there's a lot going on, Miss Love. There's a presence. Yes, that's all. That is all I'll say. Court says, but I see it from just being in the courtroom and tracking. How many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? Whoa. This case is like an old house that the present honorable judge is tasked with renovating. Every time a piece of pasted up wallpaper is removed, more rot is found hidden under. Okay, this is too soon, man. This is too soon. This hits me right in the core. More rot is hidden underneath. No Herculean effort to the present court can fix the due process violations of the last judge. This house must be torn down. A mistrial should be declared and a retrial barred due to prosecutorial and judicial misconduct that has goaded Kendrick into the present motion. Wherefore, Kendrick respectfully continues this request that this honorable court declare a mistrial based on at least due process violations of Kendrick's constitutional rights under the federal constitution and the constitution of the state of Georgia. Wow. There's some spice here, guys. There's some spice. Hold tight. We've got trying to see how we can show this.
I think I'm about to catch a whooping.
I don't want to read I don't think we can get through the 19 pages before court starts. Let's see if we can court hop over to what happened this morning. So give me just a second. Let's see. I don't want them up anymore. Let's see what Young Thug is doing. What happened this morning? They're on break right now. Do we have a timestamp, Amber? Let's watch how the Young Thug trial started this morning, just briefly, if we can. Give me just a minute here. Oops, that looks wrong. Box sources. Give me a second. We'll get this pulled up. Okay. 1 is 6, 2 is nothing, 3 is 7, and 4 is MP2. Sorry, my switcher, I forgot I turned my switcher off. I have to reset just a couple things and we'll have this set. There we go. Okay. Let's see if we can take a quick peek at court just briefly. Why is it not playing?
I understand that the parties have a proposal with regard to at least a portion of Mr. Copeland's testimony. Sorry, I didn't have this turned on. So what I said was I trust everybody had a productive evening, and I understand that there is a proposal with regard to at least a portion of Mr. Copeland's testimony, so I'll hear what that might be.
Good morning, Your Honor.
Morning.
Simone Hilton for the state of Georgia. Last evening, myself and Mr. Shard had a brief conversation regarding the testimony of Mr. Copeland.
Yes.
I believe the defense counsel have to speak among themselves in order to determine what portions of Mr. Copeland's testimony they are asking to be kept. And so we believe that we need a copy of the transcript.
Okay.
So that they can have that conversation. Once defense counsel has that conversation, then they'll speak with the state about their proposals and we can move forward from there, Your Honor.
All right, so I don't believe that I think we have the 7th available. I don't know that we have the 11th and 12th yet, but I think we've reached out this morning to Ms. Weaver, the court reporter, and I know she has some other people working with her as well, so we'll endeavor to get that to y'all as soon as possible. And she's been pretty fast with the turnaround, so we may even have parts of it by the end of the day. So that seems like a reasonable approach. And then I would think that the next thing we can do, to the extent y'all feel like you want to revisit evidentiary issues with regard to any of the videos, or I don't think you had gotten to the jail calls yet anyway, but with regard to the videos, we can probably do that now. Do y'all think? Otherwise, give me something else we can do this morning.
Yes, we can do that. If you can, we just need to get that material very quickly to the office. I mean, to the courtroom.
All right. Send somebody to go do that, please. And I'm, has anybody thought through yet, and maybe we'll have ready soon any kind of potential instructions for what we're going to be telling the jury about either Mr. Copeland's testimony, well, I guess generally Mr. Copeland's testimony, and then I'll entertain what we're going to, I am going to say about the fact that here I am instead of Judge Glanville. But I mean, for that, I'm thinking essentially just, I don't know, some matter has required a substitution of judges, and that's about it. I don't plan to tell them really much more than that. They don't need to know why.
Your Honor, given the conversation Ms. Hilton had with the defense last night, in that some of them may be seeking to have some portions of it kept, depending on the court's decisions regarding our respective positions, I don't think we can craft at this point. For instance, if we decided, everybody said, let's just keep it, then we would just keep it, understanding that's likely not going to be the case until we know the respective positions and the court's ruling on that. I don't think we could endeavor to craft it.
Yeah, that may be true. Okay. Yes, sir.
Good morning, Your Honor.
Good morning.
Here we go.
Good morning to everyone. Your Honor, I wouldn't, and Mr. Adams can opt out of this if he believes it, but I'm objecting to anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth, that he has been found to be disqualified and removed from this case for his conduct. And that's my instruction that I worked on. That's what I'd like you to do.
All right, well, I'll consider everything once I've got everybody's proposed instruction to the extent anybody wants to provide one for me to think about.
Thank you.
And Your Honor, I believe that the statute, if I'm not mistaken, regarding recusal specifically, speaks to the fact that that is not to be made a portion of the case in chief, of the main case. I will get the exact language that I'm speaking of.
All right, great, thank you, I appreciate that. Okay, anything else?
Yes, Your Honor. We also briefly discussed yesterday the exhibit list, talking about how we can resolve working through the exhibit list. And my understanding from Mr. Shard, I'm not sure if Mr. Kokomo was finished yet, but Mr. Kokomo, who's his legal assistant, and another legal assistant, we're actually working through the same thing that our legal assistant is working through. And our hope is, hopefully the court will be okay with this. By next Wednesday, our legal assistant would have gone through every video to assure we have all of the correct exhibits. But it's taking time because she's literally watching every single time we're in court.
I'm not okay with waiting until next Wednesday. I mean, I'm hoping, and it may be a false hope, but I'm hoping that we'll have a jury back with us by next Wednesday. So that needs to accelerate.
Okay, we will work on accelerating that list to get it to the court. But I believe that they're working on it as well.
Well, they need to accelerate as well if their thought was next Wednesday. I mean, like, I'm thinking this Friday, okay? Which is the day after tomorrow. All right, with regard to, and you're talking about the videos of his testimony, right? Or are you talking about?
No, I'm sorry, I should have been clear. To confirm what exhibits have been admitted and not admitted. That's what we've been working on. No, that's
the giant list of
list of exhibits.
Yeah, that's fine. That can be next Wednesday. That's not that urgent. As long as we've got that correct by the end of the trial, that's all that really matters.
Yes, Your Honor.
For that. I thought you meant Mr. Copeland's testimony.
No.
Okay,
Your Honor,
all right. My misunderstanding then. Okay. All right. So with regard to the video interviews of Mr. Copeland, I suspect there are parts of those that the state knows they intend to be using or suspects very strongly they probably need to be using. So can we either come to some form of an agreement about evidentiary rulings that were already made, and or let's figure out what I need to do again?
Yes, Your Honor. I believe after we had the initial arguments regarding some of the redactions, some of the redactions we did concede on. So once I get that list, I can let them.
Well, I've already seen those with regard to a couple of things, but I haven't gone through. I mean, I was looking at, for the transcripts I had, the arguments that y'all had already presented, and I saw that there were maybe like a couple, I don't know which, I can't remember right offhand which dates I've already looked at, but there didn't seem to be that many that y'all just conceded. Seemed like y'all argued and needed a ruling for most things, but what I'm saying is, having argued it once and having gotten a ruling from a judge who knows what he's doing, whether y'all like him right now or not, do I need to re-listen to each argument and make my own determination, or can y'all agree that, hey, you know, the law, regardless of us arguing our various sides, the law probably is this and we're okay with that ruling?
We believe out of them, we believe, and I'm sorry, Your Honor.
Go ahead.
Out of them, we believe that there might only be two that we think may need to be re-argued. Okay. I just want to, we don't think there's many, at least from the state's perspective.
All right, that's good.
Your Honor, I'm speaking for myself. Yesterday, we received a transcript that was a transcript of an ex parte meeting that occurred on Friday.
Right. This is the
before
one.
the Monday.
Sorry, just so that we're clear for the record purposes. This is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had, and in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
Let me be more artful, yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th. We sat there after finding out about one ex parte meeting and having to drag the truth out. We sat there and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Caleb Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in this ex parte meeting, things. The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel, Mr. Steele. And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in the trial. The judge that says not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that hands
this is spicy. We're going to pause
Mr.
this
Copeland
because
the list
Apple
of
River
questions
has come on live.
Do we need to revisit those rulings?
Okay, so we're going to pause right there for just a minute. We're going to jump to Apple River very quickly, and let's see.
Away.
Here we go.
After he was insulted, he charged up onto the boys and grabbed onto their tube. I'm going to start by talking about the seriousness of the offense.
Are you going to project on the monitors?
Yes. I just have a exhibit labeled Exhibit 1. It just has 2 photos on it. Yes.
They're white balancing. Now those zoom back out.
Obviously, a homicide, any homicide is serious.
Was that the knife?
In this case, Nikolai Mew killed 17-year-old Isaac Schumann.
I thought it was a smaller knife.
There's very little I can say about the effect on the victims that hasn't been said or expressed better by his family, both at trial and today with the victim impact statements. Part of what makes this so tragic and horrific is how easily Nikolai Mew could have avoided all of this. As I said, after he was insulted, he could have just let the boys float away. Instead, he charged up onto them. When the boys were yelling at him to leave, he doesn't. When another group comes to intervene to help to yell at him, tell him to leave, he doesn't. Instead, while multiple people are telling him, pleading with him, yelling at him to leave, he's smirking and he takes out his pocket knife. The defense filed a memo that presumes that Nikolai Mew actually believed his life was in danger, and that belief was just unreasonable based on the verdict. I don't think that's the case. I think the evidence shows he snapped, as we argued to the jury. I think that's evidenced in his attempt to flee afterwards to avoid responsibility, and his washing the knife, ditching the knife, saying nothing to his friends and family that were there. His playing dumb with Sheriff Knutson when he's first apprehended, acting like he didn't know what happened, saying he saw what looked like kids being kids. Maybe they were fighting. I think it's shown by his countless lies in his interview with Lieutenant Hart.
We're a moment or two behind. I'm going to catch up to live really quickly here by speeding up.
After as he's standing there smirking, as we all saw in the trial and screenshots in the video, holding his knife, he never raises his knife. He never says, "Get back," like any reasonable person would do if they're afraid. I think anybody who's studied self-defense statistics whatsoever knows how many potentially violent situations are diffused simply by somebody pulling a weapon if they feel threatened and saying, "Get back, I have a weapon." He didn't do that. He held it down by his side where nobody saw it. After he took out his knife, when there's just 2 small females standing in front of him, he then punches Madison Cohen in the face, starting the physical altercation. It had, up to that point, been strictly verbal. Understandably, unsurprisingly, after he punches a barely 100-pound female in the face, he gets hit back, and he gets up and starts stabbing anyone within reach, regardless of their role, what they're doing. Riley was just standing there, as witnesses testified. Even after his friend Ariel was there, even after he'd stabbed multiple people, even after AJ is disemboweled, trying to hold in his intestines, Nikolai Mew, instead of going back to his group, walks away from them, up to Dante, and stabs him in the chest. There's nothing that shows other than vengeance, because Dante had punched him, so he was going to get even. He then cleaned the knife, ditched the knife, and returned to his group. He encouraged his group to leave. He never called 911. He never tried to help any of the victims. He casually floated by the carnage that he left. Members of his group saw people getting CPR. But for the prompt response from the Sheriff's Office, Somerset Police Department, AJ likely would have also died, also but for the medical intervention. But for the prompt response from law enforcement, Nikolai Mew might have gotten away. He tried, once he got to the exit, tried to walk past the first officer. It was only because of the video and the screenshot that was circulated by law enforcement and witnesses that he was found. Because law enforcement thought they were looking for a single person, shirtless. Mew had changed his appearance, put on clothes, hat, sunglasses, and tried to just disappear with the crowd. In his interview, he made up many bizarre lies, some of which I think show his own state of mind, including his own recognition that he should have just left, because he specifically told Brandy Hart, Lieutenant Brandy Hart, they told me I couldn't run away. Obviously not true. That's what they were begging him to do. He said, I don't know why they wanted to scare me with knives. Not true. He was the one with the knife. He said he absolutely did not have a knife. Obviously not true. He pretended, feigned to not know the state of the other people. When he was told that 4 people went to the hospital and 1 was deceased, he said, oh no, as if he didn't know and he hadn't floated by the carnage that he created. The river was running red with blood. AJ Zid disemboweled and he pretended to not know. The defendant's actions, as we've heard today from the victims, affected so many people beyond Isaac and the other stabbing victims and Madison Cohen. It affected his friends, his family, classmates, teachers, the friends and family of the other victims, innocent bystanders around the river, the sense of safety in our community, and what's otherwise known as a recreational area. We heard from the victims earlier the lifetime physical damage as a result of this for AJ and Riley. There's obviously a lifetime emotional damage for all of the victims and family. Dante and Tony were lucky, no vitals were injured. Madison Cohen, for the battery, her injuries were pretty minor. It was pain, essentially. But she talked to the PSI writer about the emotional trauma from this event, as we've heard from other victims this morning. When we first met with Madison, she told us similar things that she told the PSI writer, that about how when she got to shore, Isaac, who she didn't know was there getting CPR, and that Isaac's mom showed up. And Isaac's mom was holding his feet and saying he's going to be okay, and sobbing. And Madison, sobbing, telling us this, said she decided she's never going to have kids because she can't stand the thought of suffering trauma like she witnessed with Isaac's mom on the shore. Proper consideration for sentencing, as outlined in Galleon, is the character of the deceased in a homicide. We've heard about Isaac from his family. His mother also provided us with some letters from other friends who aren't victims, describing what kind of person Isaac was. His friend Alex Vang, who was with him on the river, described him as always wanting to make sure everyone was happy, always cracking jokes, generous, talked about how they'd spend times talking about their dreams and goals after high school. He said Isaac was one of the people who inspired him for his future because of how driven and motivated and energetic Isaac was. He talks about anger, grief, and guilt following this incident. Landon Wire, who was with Isaac, talks about how this has affected him, loss of one of his best friends, about how he'll be scarred and traumatized by seeing the blood, the guts, and losing his friend, about how he'll never get the chance to grow because of the actions of Nikolai Mew. Juwan, who filmed the video, hopes that justice will be served and his conviction is a step forward, but talks about how he'll never replace being able to see Isaac again, having one more hug, telling him he loves him. Isaac's girlfriend, who he'd known since middle school, talked about how they were looking forward to the future and what kind of house they would buy. Described Isaac as hardworking, intelligent, caring, charismatic, funny, and loving young man. That she knows he's protecting her and his family now. The character of the defendant is also relevant for sentencing. The defendant's 54 years old. As the PSI talks about, he came here from Romania when he was 15, worked as an engineer, had no criminal history. He's been divorced 3 times. He has one son who lives in Romania who he hasn't seen in 10 years. One odd thing from the PSI I noted is he spoke very highly of his dad and denied any abuse from his dad. But there's a public restraining order where he and his brother said that they're abused by their father. I don't know how relevant it is. It's just a little bizarre discrepancy I noticed. He talked a lot about his own struggles, thought he was depressed and his health issues. In the PSI, he talked very little about the effect of his crimes. And that's been a present fact throughout this case, is no remorse from the defendant. One would hope, even if he truly believed this was self-defense, he would at least feel sorry that somebody was killed because of his actions. There's been no evidence of that. At trial, he was only emotional talking about his dog, never emotional about the horrific injuries or the death of Isaac. I'm sure his attorney, and maybe even himself, will talk today about how remorseful he is. I think that rings hollow. Every defendant claims remorse at sentencing. What's much more enlightening about how he truly feels is how he acts, what he said leading up to today. All he really mentioned in the PSI that would suggest remorse is he's very sorry for everyone involved. No specific mention about killing Isaac Schumann, a 17-year-old, or the loss of Isaac for his family. Throughout trial, the heartbreaking testimony of Elena and the other witnesses and victims, there's no emotion from him. And I believe his true feelings are evident in his calls with his brother. He has numerous jail phone calls with his brother speaking Romanian, or perhaps he was a little less careful about what he was saying because he thought maybe it wouldn't be translated. He has a tendency, well, one, he consistently disparages the boys. He has a tendency to refer to them as other than human. And there's no, and defense can correct me if I'm wrong, there's never any hint of remorse for his actions. Instead, I'll just read from one section. He says, "At jail, these bastards got me here. Well, it is what it is, but at least I'm alive. I was able to fight in order to survive. You got it? At least I survived the attack. And now look, the bastards are free. The bandits from hell, they are free, and I'm here. I'm victimized again." No, the bastards are free, and I'm here. No acknowledgement whatsoever that Isaac is not here. He killed Isaac. I'm sure there's going to be a large attempt to paint him as this great person. His jail phone calls, I think, tell a different story. He refers to Lieutenant Hart as a dirtbag policewoman, that wretched lady, suggests she's hiding evidence. The common theme is throughout his calls, he can't accept any personal responsibility. He blames Lieutenant Hart. He blames his own group, including his wife, for not stepping in. He also can't stop lying in his phone calls. He maintains there's other knives. He maintains with his brother, even well after he's arrested, after he's seen evidence, that he didn't take out the knife until after he was attacked and down in the water. That is undeniably untrue. You can clearly see him in the video before anything turns physical, smirking and holding that knife with the blade open. He claims he didn't try to leave the scene, claims he tried to run away from the confrontation. His continued lies, no, even he knows it's not self-defense. He didn't think it was self-defense. He knows it's absurd when if somebody looks at all the facts to claim self-defense, so he continues to twist them, even with phone calls with his brother. As well as that section I read where he described the boys as demons from hell, he describes them as bamboo bastards. But most often he refers to them as bastards. At one point, expressing frustration that his wife and friends didn't get to help him, we get a little bit more insight into his thought process. He says, friends, but when it's about a fight, they don't come to intervene. Man, had it been Sandy in that kind of situation, surrounded by those guys in the water, I would have rushed there, terminating those guys. There's so many, like you said, it would have been more of them like that, bellies up. So that's the cold and callous way he refers to killing Isaac, as leaving him belly up. Obviously, he's still angry. As we argued in the trial, he was angry at the time, he wasn't afraid, and he's still angry and accepts no responsibility. Clearly has no idea that self-defense is meant to stop a threat, not to terminate people and leave them belly up. I'm sure defense is going to spend a lot of time talking about his lack of criminal history. It's not unusual we see horrific crimes committed by somebody with no criminal history. I'm sure there's going to be a lot of discussion about him being a peaceful person. A peaceful person doesn't rush up on a group of teenagers because they insulted you. Doesn't refuse to walk away. A peaceful person doesn't take out a knife when they could have just walked away. Doesn't start a fight and stab 5 people. I think there's more. A big question in this, I think defense is going to argue, is he's not a danger to the public. One, I think the crimes speak for themselves. Clearly he's a danger. No reasonable person in his situation would have acted like he did. This would have ended before it was even anything. Talking about leaving people belly up and terminating them is not the words of a peaceful person. His lack of remorse is certainly an indication of his lack of respect for human life. His dehumanizing the boys, including Isaac, with this terminology he uses to describe them. Another thing that's perhaps a clue that maybe this shouldn't be that surprising is when law enforcement went to his residence after he was arrested, they got consent from his wife to search his Jeep. In that Jeep, they found a machete concealed. Can we have the screen?
That's that secondary knife.
That was concealed between the center console and the passenger seat. When law enforcement asked his wife about it, she said, described that he has that for protection for possible road rage incidents. She then later said, well, actually, maybe it's from camping. I think nobody hauls camping material, camping equipment, concealed where it's in easy reach of the driver. It's absolutely bizarre that somebody would decide, one, that they're so concerned about road rage that they have to carry a weapon. I completely understand people conceal carrying, but to do it specifically because of road rage is strange. But absolutely bizarre is choosing to carry a machete. That makes no sense to me. It's not a defensive weapon if he's attacked in a car. It's only an offensive weapon because he'd have to get out of his car. The state's recommendation—
I don't agree with that statement.
—is a total of 60 years initial confinement.
You can defend yourself outside of your car.
For count 1, for the homicide of Isaac, the state's recommending the maximum sentence of 45 years initial confinement, followed by 20 years extended supervision. For the recklessly endangering safety, counts 2, 3, 4, and 5, the state's recommending 6 years initial confinement, followed by 5 years extended supervision. And on count 6, the battery, the state's recommending 1 year, with all counts running consecutively. The state believes a lengthy prison sentence is appropriate to protect the public. It's appropriate as punishment. I know defense is going to talk about that a lot. The reality is that's a proper consideration, whether they like it or not. Punishment is a consideration in sentencing, but mostly to not depreciate the seriousness of the offense. It's hard to put into words how graphic and horrific this was. Everybody saw the evidence at trial. The public didn't see all of it. Some of it we kept or tried to limit what was shown because it was so graphic. The only other thing, Judge, is the state would ask for 30 days for restitution. I believe there will be some. I'm hopeful that we could reach an agreement, but if not, we'd ask for a restitution hearing.
Is that all?
Yes.
Why don't we take a short recess? It seems to be a logical place for a break. We'll come back at 9:45. Mr. Mew and his attorneys will be escorted to the waiting room. We'll reconvene in 10 minutes.
Short break now. Short break in the sentencing. Mr. Mew convicted. That's why he's appearing in jail clothes and shackled. The court has made the decision this morning, I think on a surprise decision, not to allow the family statements, which happened previously, to be aired. So we heard a little bit of a synopsis of some of those comments, which were either read out in court or possibly might have been provided to the prosecutor. The prosecutor is asking for basically the maximum in this case, which effectively would be a life sentence. This is a hard one to watch. We were divided on this case when it occurred. The jury ultimately just determined that his response did not meet the situation. It was not a reasonable response. So we'll jump back to that one as soon as it happens. I'm not sure if we can get through 10 minutes more of the young thug trial. Let's see here. Turn this one off. Super source. That's not it. There we go. Do we want 10 more minutes of the young thug while we wait for trial to come back? Let's try that for a minute. It's getting spicy. They're making some great arguments here that they want they're demanding change in young thug. Just 1 second here. Let's cut there and let's see if we can play it. Where's my mouse? Oh, there it is.
Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay. It's not okay. It's offensive, and it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
Yes,
I can tell.
My steam's been coming off my bald head all night. Nothing about this is okay. Yes, we need to revisit everything. That's my stance.
Okay, thank you. And I think that I understand you being upset, and I understand why you and probably some of your fellow defense counsel on this side of the room are upset. I do not think that everything you said is a fair characterization of what that June 7th transcript reflects. But once we have the official copy, that'll be made a part of the record, and that will show what actually happened, what actually was said. As to any kind of legal error that may have been made with regard to rulings prior to Mr. Copeland's testimony, assuming this case goes forward and assuming there is any kind of conviction, I then assumed that there will be a motion for new trial phase, which at that point I can appropriately revisit things, and then potentially an appeal, at which point those things can be raised. I am considering and reading what y'all gave me yesterday to make a ruling on the substantive matters of that ex parte, and I can consider the June 7th ex parte as well, because I suspect y'all asked me to do that. And if I determine that that is such, that there was coercion that is unconstitutional or structural error, then I will grant a mistrial. If not, then the case will move forward and we can consider again all of the evidentiary rulings with regard to the videos and audios that might be used with Mr. Copeland, because that's the witness that we are on the stand with right now. I would, and I know this is hard to do, but I would like for everybody to try to take some deep breaths and move forward professionally. A lot of what y'all are talking about doesn't make it any easier, but it happened a month ago. I know tempers flared all around, but
I just found out about it this morning.
We need to move forward with this in whatever way it's going to move forward in a calm and professional manner, okay? So then with regard to what we need to do evidentially, I guess I will need to hear from the state as to what y'all think it's very likely for you to be using while you're examining Mr. Copeland, and then I will entertain evidentiary objections, responses, and we'll consider what's coming in.
Thank you, Your Honor. And we're getting that ready as we speak to present to the court. And I'd also like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level a assertion that Mr. Sharp is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Okay, well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well. Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that. But the reminder is to everybody, okay? And I mean, I've said it, so let's act accordingly.
Ron.
Yes, sir.
If I can address the court briefly. I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's got it.
Thank you, Your Honor. Mostly I want to make sure I bring it to the court's attention because, again, and I've followed the request of the court to not argue what's already in the papers, but I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. I, like Mr. Sharp, am extremely upset having read that transcript. Myself and my fellow outside agitators over here, I assume that they are upset as well.
Yes.
And
I don't think, honestly, I don't think that that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
Well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't there, we don't have a video of it, so I have no idea specifically if that was not referred to us. We don't know, do we? We don't know. And what I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him, and now I have been made to look like an idiot. So I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say, I haven't, obviously you just filed it and I haven't had a chance to look at it yet, but I will consider that in the overall context of the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are. If y'all feel like you need to get it off your chest, come on.
Here comes
Now's the
Attorney
time.
Steele.
I got one more thing to say to and then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor.
I mean, I don't either.
Okay.
I don't either. I already said I understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was when I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, it's coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right, well,
Okay, so we're going to pause right there. We're going to be coming back to the Apple River trial, they're just going to be getting back from break in just a minute. Young Thug was spicy this morning. Oh, it was spicy. The yelling is, it's hurting my ears. It's hurting the mics. The courtroom audio system is not designed for that volume of argument, but it's not done. It's not done. Oh, my goodness. We have a transcript to read in that one, but what we have on the schedule for today, we're waiting to go back to the Apple River trial where Mr. Mew will probably have an opportunity, and we might also hear from the defense side additional comments about prior to sentencing that the judge should take into consideration. When that comes in, once that's done, the judge will hand down the sentence. At the conclusion of that, we're going to be jumping to, I believe, Judge Boyd's courtroom where she has a court case. I don't know what time it starts on that one, but she has a murder trial in her courtroom, which we've wanted to watch. So we're going to be jumping to that one. I believe it's a vehicle, a car crash murder trial. But wow on the spice. That was the Young Thug from this morning. We're just waiting for the feed to come back from courtroom as we speak. As soon as the talking heads are done doing their talking.
It would seem like proceedings are imminent. We'll keep an eye on this as we go.
No, not quite yet.
Is there a typical length of time you'd expect a defense? I mean, would they go a little?
They're doing their talking head thing, so we'll wait for the judge to.
This argument wasn't
to come back here in just a moment. All right, so we're going to do. Oh, here we go. I think he's coming back right now.
Judge Waterman, let's take you out to St. Croix County Circuit Court, Hudson, Wisconsin.
Okay, we are back on the record. The attorneys are present along with Mr. Mew.
Really
Mr. Nelson,
close.
will you be delivering Mr. Mew's argument?
Yes, Judge, but I believe the state had something to add before I start.
I just noted my total was incorrect. All the specific lengths I gave for recommendations is correct. The total of initial confinement is 70 years.
Thank you. Mr. Nelson.
Thank you, Judge. I just want to start by obviously acknowledging that this was a tragedy all around. We completely understand and appreciate the heartbreaking loss and the grief that was suffered by the Schumann family, the other victims, and their entire family, their friends, everybody here in the courtroom for the most part. It's obvious that Isaac Schumann was a unique and special human being that was loved by innumerable people. As Your Honor knows, here today, defense has a unique role in this process. And so while as a human being, I definitely heard what was said, I'm going to focus on our role today, and I'm going to focus on the galleon factors. And the galleon factors, as we all know, and we'll talk about it later, talk a lot about Mr. Mew, the seriousness of the crime, and the need to protect the public. So I just want the court to know, and obviously the public to know, that we heard the victims, we understand, and appreciate that. I'm just going to move through and talk about the galleon factors. I think it's always important to, when I think of galleon, which I think it was cited in my sentencing memo, Your Honor, and I'm sure Your Honor's heard me say this before at other times. I've been in front of Your Honor numerous times. But my favorite quote in all of Wisconsin jurisprudence is from paragraph 36 of galleon. Experience has taught us to be cautious when reaching high consequence conclusions about human nature that seem to be intuitively correct at the moment. Better instead is a conclusion that is based on more complete and accurate information and reached by an organized framework for the exercise of discretion. I know Your Honor knows that quote. I know Your Honor will appropriately exercise your discretion. I didn't mean to imply that you wouldn't, but I think it's good for all of us, and I know obviously the court, Your Honor, is my audience today, but this isn't happening in a vacuum, and I think it's important for all of us as members of the court system to take that real responsibility on when we speak about things of this serious nature, which at the end of the day, this is as serious it gets in our profession, in the criminal justice system, the sentencing. How do we deal with loss within our society, within the court system, within this courtroom? It's a profound question that I think demands incredible attention, and that's what I'm going to try to give it today. That quote ends with the exercise of discretion, and in galleon, again, as Your Honor knows, the courts talk about discretion in a way that makes clear the use of discretion is using the process of reasoning and a logical rationale. And so if you indulge me for a moment, just to quote from paragraph 3, discretion is not synonymous with decision-making, rather the term contemplates a process of reasoning. Paragraph 6, in this opinion, we examine the process of reasoning. Paragraph 19, quoting McCleary, the term discretion implies a process of reasoning. This process must depend upon facts that are of record and that are reasonably derived by the inference from the record and a conclusion based on a logical rationale founded on proper legal standards. They go on to say in paragraph 22 more about a rationale. Paragraph 39, a rational and explainable basis. Paragraph 49, a rational and explainable basis. Paragraph 15, a rationale for sentencing. Decisions must be knowable. And I'm going to address that a little bit more when I do get to the, I think near the end, when I address punishment and retribution. Because I think this framework for us here in a court system using rationale to try, maybe unsuccessfully, but to try to figure out what we do as a society when loss has been suffered. And part of that rationale, Judge, is clearly morality, right? I don't want to go on too far about, what's the purpose of the criminal justice system, but I think in many, many, many ways it is a system to try to impart and show
I feel
our
really close
common
to the
morality
judge.
and the morality that we believe in as a community. I think morality, and I think there's hundreds of years of philosophers who support that essentially morality is by its nature both forward-looking and functional. And I think that's a key theme at any sentencing is we're looking towards the future. Obvious, we're here about the past, right? There's been crimes that were committed that he was convicted of. There's loss that happened in the past. But morality in sentencing, I think, at its core is forward-looking and functional. The natural purpose of morality, even the retributive impulse, is to shape future behavior advantageously for our community, for our society. Any reasoned moral response to past behavior must consider the best means to achieve what our community's desired ends are and how most effective we can be on those future offenses. And I say that, and I'm maybe taking some things out of context, but one of the matters that Mr. Anderson addressed, right, in his comments, and I appreciate this, that he was critical of Mr. Mew's actions on the river. And he essentially said, and Your Honor just heard it, so I'm not quoting word for word, but what I heard him say, he was critical because according to Mr. Anderson in the state, Mr. Mew was acting on vengeance to get even. That's one of the things that the state had said. Now, I don't want to get, this isn't the time for factual disputes. I get that. So I'm going to put that aside, whether I agree with their conclusion about what the facts lead to show. But what we know and we both agree upon is that's a recognition that vengeance is an emotion that we ought not promote. Vengeance is not something that we ought to model. Vengeance is not something that I think any of us should aspire to or aspire others towards. Justice is different than vengeance. And I don't think this court, any court, while the natural human feelings of those who've suffered loss may involve those very instinctual, common, emotional feelings that all label vengeance or some sort of strike back. That is not something we all agree we should promote. And my hope is at the end of this that Your Honor will have some words to address that and address the meaning of sentences and the purpose of that and how they may differ from vengeance. So back to Galleon. As Your Honor knows, Galleon cites the law, the starting point for the law on any sentence, even this sentence, and I'm quoting the law. Probation should be considered as the first alternative. That's what Galleon says. It then quotes Bastion, B-A-S-T-I-O-N, paragraph 25, adopted the ABA standard 1.3 relating to probation. And again, as Your Honor knows, and maybe Your Honor will address this in your comments, but this is the framework where we as lawyers in the court of law in a in a system designed by social contract that we've all agreed upon. This is the framework which we do. And it says probation should be the sentence unless the court finds that, 1, confinement is necessary to protect the public from future criminal activity by Mr. Mew, or 2, Mr. Mew is in need of correctional treatment, which can most effectively be provided if he is confined, or 3, which I think is what the majority of what we'll be talking about today, I will be, is number 3, or it would unduly depreciate the seriousness of the offense if a sentence of probation were imposed. So with that framework, Judge, I want to talk about those 3 different factors, or 3 different questions that need to be answered. Obviously, within that, Galleon also talks about the 3 sentencing factors, which I think are somewhat parallel, if not consistent with that, and that is the character of Mr. Mew, the need to protect the public, and the seriousness of the offense. So I'm using it in the framework of these 3 questions outlined by the standard 1.3 of the ABA standards. So first off, is confinement necessary to protect the public from Mr. Mew? That's where I think we think of his character, right? And I understand that the state and some of the other speakers today made comments about Mr. Mew's character, and I understand why they may have those opinions. But the facts, the cold hard facts, are that Mr. Mew, prior to this time when he was on the river, has never been in trouble. He was an upstanding, moral human being. He had, as you know, in the sentencing memorandum and in the PSI, but just to quickly outline, he was born in Romania. He and his family, for lack of a better term, were treated poorly there. A circumstance that was outside of his control, and they managed to leave that circumstance and come to America. But like some other things in Mr. Mew's life, that wasn't in his control. He didn't sign up to be born into a communist Romanian country. He didn't sign up to be persecuted in that communist regime. He came here and had what I think we would all consider the American dream. An immigrant, came here, he learned the language, he adopted America, he assimilated into our country, and he was a productive member of society, getting an education, being employed, and having positive relationships throughout his adulthood. The state has mentioned some things about his character that I feel like I don't want to belabor it too much, because I don't think at the end of the day there's really much question about his character. The state's talked about his phone calls, right? What Your Honor probably knows is he's been in custody for 2 years and a day. About 732 days he's been in the St. Croix County Jail. During that time, he's had some phone calls. The state mentioned some of these phone calls. I will just say, without us being distracted by these phone calls, that we dispute the translation on many of those phone calls. In particular, the word bastard. That's not the Romanian word that Nikolai used. I think the proper translation would be an unfortunate. And so that's a very different context in which this was said. Second thing I think is Mr. Mew has been in custody for this time. Like, I think anybody, whether he was involved in this traumatic event, right? He's been suffering PTSD while he's in the jail. That's documented through the jail records, through the medical records. He's been going through his own process. These phone calls that are mentioned, you don't get a timeline. You don't get a date. Many of them, based upon my memory of those phone calls, which wasn't a huge part of the trial, was these happened in the first 30 to 60 days of his incarceration. These weren't from yesterday. These weren't from last month. These weren't from around the time of the trial. These were much, much further back in time. And I say that because remorse is something that the state talked about, and they talked about it in the context of Mr. Mew's character. I think Your Honor knows the criminal justice system in America is good at several things. It's not really good at allowing sometimes a space for a person in Mr. Mew's position to express remorse in a safe space. The only people that he'd be able to do that with are myself and Mr. Cherofisi. I don't want to make myself a witness, but I can tell Your Honor's office of the court, he has processed this. He has shown in the numerous times, the tens if not hundreds of times that I've met with him, remorse over different times in the action. A lot of mixed emotions, probably not one emotion that he's been showing, but there has definitely been remorse. One story that he's given me permission to tell is very soon into this, after the event. The state approached me as his lawyer and asked about the release of Isaac's body. As we heard from his sister, Isaac's body was evidence. That must be a devastating thing that they had to deal with. And Mr. Anderson reached out to me to see if the defense would release the body. And of course, I did my duty. And the first thing I did is I went and I spoke with my client, Mr. Mew. And when I made that question, I approached Mr. Mew with that question, he looked at me aghast. He could not believe that that had not already happened. And he broke down emotionally and wept He just wept. Maybe there was other things that came in. Maybe this was a time when I first met him, when we were starting to get to know him. Maybe it's a time that this loss that had happened became more real for him. But in that moment, he showed what I think was remorse. They weren't there to see it. And they weren't there to hear about it until today. And if we could redesign this criminal justice system in a way that maybe we could give some of those things to the victims' families beforehand as we're going through this, I think there might be other healing, there might be other things that can go through. I understand and appreciate why they might feel the way that they do. But I can tell you, I've been with him. I've been with him over those 732 days, and he has shown remorse. Is it mixed? Is it complicated? Absolutely. Are there times that he has some other feelings that are all mixed in with this? Yes. But I submit to you that he has shown remorse, and it has become more and more and more so as we have moved through the process. His character, Judge. At the end of the day, we're here to judge him on his actions, right? He's here because of an action. And I think that all of us as human beings, at the end of the day, we have thoughts, we have opinions, we might make comments, and sometimes our words might be considered actions. But at the end of the day, when you add it all up, you're going to judge me, all of us, the world judges us on our actions. And this day, July 30th, that 2 minutes, right? We'll expand the time limit. That's the first time that his actions, I think, become into question. And what, in any other context, I'm not trying to belittle what we're doing here as serious. If I make an analogy that's poor, I apologize. But in any other context, if we were seeing somebody's performance across a field, whether that be in a sport, whether that be in academics, or whether that be in a profession, if they've demonstrated through factual data points, and we measured all of their actions, and they had one data point, horrible, glaring, big red data point that's at the bottom of the scale, right? If all of our points are measured across a scale, birth to death, and we hopefully develop and grow as we go across time, and our actions improve on our development of moral development in society. If somebody has one data point that's below that line, common sense tells us in every other capacity, in every other field, you don't overcorrect based upon one data point. And that's why I think his character, and I get that that's just one part of this, I don't want to say it's equation, one part of this analysis, but that's what common sense tells us in everything else. If you objectively measure it with the PSI did, he is low risk statistically. He didn't ask to take the PSI. He didn't ask to get measured on Compass. But it happened, and one of the things that the Compass came back and told us is he's low risk, which makes sense for somebody who's 54 now. At the time he was 52 and had never been in trouble before. That's low risk. That's what the objective evidence, if you were going to use a process of reasoning or rationale, that's what that shows. I do think, and I appreciate that there's been a guilty verdict. I'm not trying to relitigate matters about what happened on the river. But I think when you think of his character, and later when you think about need to protect the public, or when you think about punishment, all of those aspects, we have to consider the circumstances of the event. That's just the plain reality of this. And the circumstances, the factors, the conditions, the circumstances played an essential role in shaping Mr. Mew's reactions. He didn't put himself in that position. I've definitely heard talk, and I will address it later, about could he have gotten himself out of that position in other ways. I understand that, and I'll address that. But we have to know that he didn't put himself in that position. The state, I think even again, in their acknowledgement, right, one of the things that they were critical of him is they said he should have de-escalated by showing the knife. and I'll get to that. But I think that's also just a common sense acknowledgement that somebody else, other people, the circumstances were being escalated by people other than Mr. Mew. He was in that position. There may have been other things that he could have done to do that, but it's not of his necessarily controlling.
State's control. Excuse me. You see that?
So I just, again, we're here to talk about Mr. Mew, and we're here to talk about Mr. Mew's actions or reactions, and you're here to judge those, and you're not here to judge or blame others. I get that, and I appreciate that. But his actions, his reactions, did not occur in a vacuum. It did not occur in a vacuum. The second question, moving on from his character to some degree, is, and again, just I sent Your Honor a letter. There was numerous quotes from all of his family and friend. He's got numerous family and friend that are here. And some of them even asked me, could I approach, could we say something on behalf of Nick? And I appreciate why somebody would want to do that. My hope is that Your Honor, through the PSI, through the letters that that I submitted, through the letters that other people wrote and that I submitted, Your Honor gets a picture of who Mr. Mew is. And it's, while calling witnesses might help this process today, I don't think it's going to help Your Honor. And at the end of the day, I think my audience is the court. So what's the next question? The next question is Mr. Mew in need of correctional treatment which can most effectively be provided in confinement? And I think the answer to that clearly is no. There is nothing in the PSI, there's nothing in his character, there is nothing in any of the information that's been submitted to the court that he has any treatment needs. There's been this potential about alcohol. I understand that, right? And one of the things that Mr. Mew wanted me to point out regarding the correction from the PSI regarding substance abuse history, in particular pages 22 through 34. It's probably just easier for me to quote his words. It's not as much a correction as just maybe some things were left out. And his words to me were, I rarely drank any alcohol in college, and when I did, it was beer only, never hard liquor. Rarely drank more than 1 to 2 beers, and rarely until I would get a buzz. I avoided getting a buzz. I did not like beer or any type of alcohol in the beginning at 23 years old. I drank socially only. So that's, again, it's not, I don't think, nobody said that he was intoxicated on that river. The PSI acknowledges that that's not what the evidence was. Was there alcohol involved? Yes. The witnesses that testified, the witnesses that submitted to him, he's not in need of treatment for any substance abuse. There's no other need that he could only get in prison, right? And even if there was, whatever, again, I don't think that there's an alcohol problem, but I think it's undisputed that treatment for alcohol can best be provided in the community. So he doesn't have needs. He's educated, he's employed, he has no record, no past behavior. The treatment, right? I think at some point, if we're talking about sentencing is about modifying our attempts, the court system, the court attempts at modifying another human being's behavior, right? Either through moral education or giving them other tools, other skills so that they are reduced risk. In this situation, if you're talking about the morality, we have to again consider the circumstances of this event. We have to, right? I understand Mr. Anderson does not agree with my analysis of the verdict. There's probably never going to be an answer as to whether or not, to what degree self-defense was considered by the jury, or whether there's been any factual finding that he, in fact, had an actual belief that he was acting in fear. I think the evidence supported that. My conclusion, as I put in the writing, was that the jury determined that his beliefs were unreasonable, and that's why self-defense didn't apply. Your Honor is going to be able to do that in your own context, so I'm not trying to relitigate, but I think that that's important here because it's our position that he had a sincerely held belief. Mistaken, wrong, unreasonable, but the jury found it to be reckless. This is not an intentional act that needs to be modified. The state, even though they didn't say that, their implication is what he did was something that's intentional. They talk about his smirking. They talk about his doing other things as if this is something that he intended. The jury denied that. They denied that theory. They rejected that theory. This is a reckless act, and I think when we're talking about how do we modify someone's behavior, you're different than if you're modifying a reckless act than if you're modifying an intentional act. This wasn't criminal thinking, right? This was somebody who was in a situation and, again, I appreciate this people might be but overreacted, right? That there was a tool, he used that tool, and he used it to a degree that the jury found to be reckless. But I think that that becomes something that we need to consider, right? There's no treatment modification because he didn't act with malice and forethought. He didn't act with malice and forethought, right? He reacted out of fear. And while that may be criminal, that's something I think that he needs any treatment for. So again, that's all in response to that second question, right? Which really leads us to, I think, the core of this matter. Would probation unduly depreciate the seriousness of the offense? I think the answer is yes. I think the answer is yes. I imagine Your Honor's not surprised that I would say that.
The discrepancy between the two sides, 70 years
but
on
I think
one,
we need to think
probation
about
on the other.
how that should be issued, right? And I say that there are, what I'm afraid of in this case and in all cases, and in general when we talk about sentencing and we have to make sure it's not unduly depreciated, is that we have an entire system, right? An entire system of justice. That appreciates the seriousness of crimes. And for, I think, anyone, a PSI writer, an attorney representing the state, the public, the media, for anyone to try to simplify it, to say that the only way in which we can appreciate the seriousness of something is a number in prison, a length of prison sentence. I think that that is disrespectful to the entire criminal justice system. I think that that undermines all the other things that we do in the criminal justice system. Because we appreciate, in this part of this whole process is an appreciation of that. And I hope that the public, everybody understands that. There's an arrest. There's incarceration. Incarceration for 732 days, which, as Your Honor knows, that doesn't happen in most cases. Most people are let go on bond. And I'm not critical of the decision to not, but that is obviously an appreciation of the seriousness of the offense. There are numerous court hearings. There is jury selection. We went through the jury selection process in this case through all of those questionnaires, all of those other things to make sure that we get it right. And I appreciate the level of detail that we did, but that is, again, a way in which we appreciate the seriousness of this case, because we don't do that in all of the cases. I know that. We don't. And we should have done it in this case, and we did do it in this case, and we did it because of the seriousness of the case. There was clearly a trial. There's now been a conviction, right? He's now a felon, and he's going to be sent to Wisconsin State Prison System, right? Those are all recognitions of the seriousness of the offense. My complaint might be the wrong word. My criticism, I think, is of sometimes how we do sentencing is that we push all of that aside and try to say, we have to do a number, right? It's like a contest. Whoever can produce this bigger number, that's where we go to. That's not what I think we should be doing in the criminal justice system. It should be measured. It should be thoughtful, right? It should be wise. I don't think, it's not an equation, right? It's not just simply math. And while numbers are important, we don't value lives with a number. We don't value character of people by a number. There is no way that we can put into numbers the loss that the Schumann family has articulated. And I get that. I also get the desire to try to do that. But that's not something we can accomplish. We just can't. I wish we could. I really do. As one human being to another, I wish we could. But how, again, I'm not trying to imply how we in this system, we use our words, right? We use our words to explain things as galleon things. And I think it's to explain things in a moral sense. It's too simplistic if we rely upon a number. And it undermines the evaluation and the appreciation of all the other aspects of the criminal justice system if we do that. Again, duly depreciate. Appreciation, I think, is about the future and deterrence, right? There's no science, zero research that any sentence that is given in a case is going to deter others. It's one of the most studied things within the criminal justice system, and general deterrence, there's no evidence that works. So while I appreciate the desire for that we want to do that, we want to do something here that is going to change the future for the rest of the world. I get that. That's a wonderful desire to have. But the science says that's naive, that's not what's going to happen, because that doesn't happen. And I think it's even more so in a case where we're talking about things of a reckless nature rather than an intentional nature. And here's where I think I need to go back and address some of the thoughts that people have about Mr. Mew, and I understand why they would have those thoughts, and whether it's the state calling him a monster or evil, or whether those other people, right? I don't think that helps anything, and here's why. If we're really trying to craft a sentence that is going to have some influence on people watching, people who read this, people into the public, right? If the court system says and I don't think the court would, I've never heard the court use name, if considers him some sort of monster or evil, it's easy. It's easy for everybody on the camera, everybody who writes this, everybody who reads about it, to other Mr. Mew, to think of him as somebody so different than themselves that this case, this sentence, these actions don't apply to me as a human being. And that's the danger. That actually undermines what Your Honor is trying to do if Your Honor is thinking about the future and whatever happens here has some sort of influence on the public. Mr. Mew is a good man. He was in this situation and he's been convicted of doing a crime. And that doesn't diminish the consequences of his actions. But to talk about it in a way in which we other the person who does that, I think, doesn't recognize the reality of all of our vulnerabilities out in this world. All of us in different situations. And all of our also responsibilities to do what we can in different situations to either prevent and or de-escalate violence. This was not something done by a monster. This was something done because of some circumstances that lots of people played a role in. And Mr. Mew, at the end of the day, is here to be accountable for his role in that. And circling somewhat back to just the accountability, right, Judge, and seriousness of the case, as well as remorse. There's, as Your Honor may be familiar with, there's a author in America by the name of Michelle Alexander. She wrote a book about the criminal justice system back in 2010. She's also occasionally writes in the New York Times an opinion, right? And I just want to quote some of an article that she wrote back in 2009. Survivors are right to question incarceration as a strategy for violence reduction. Violence is driven by shame, exposure to violence, isolation, and an inability to meet one's economic needs, all of which are core features of imprisonment. Perhaps most importantly, according to Ms. Sarid, that's a different author that she's quoting, that wrote a book called Until We Reckon. According to Ms. Sarid, quote, nearly everyone who has committed violence first survived it. And studies indicate that experienced violence is the greater predictor of committing it. Caging and isolating a person who's already been damaged by violence is hardly a recipe for positive transformation. She goes on to say, in many ways, when she talks about accountability, and this is where I want to circle back to remorse and Mr. Muse being, through the system, isolated and not able to have contact necessarily with what we call restorative justice programs while the case is going on. Quote, our criminal injustice system lets people off the hook as they are not obligated to answer the victim's questions, listen to them, honor their pain, express genuine remorse, or do what they can to repair the harm that they've done. They're not required to take those steps to heal themselves or address their own trauma, so they're less likely to harm others in the future. The only thing prison requires is that people stay in their cages and somehow endure the isolation and violence of captivity. Prison deprives everyone concerned, victims and those who have caused harm, as well as impacted families and community, deprives them of the opportunity to heal, honor their own humanity, and break cycles of violence that have destroyed far too many lives. I quote from that, Judge, because while I recognize this is a prison case, the amount of prison is clearly in debate. It's clearly something that Your Honor is going to decide. And how do we break these cycles? And somewhat is a cycle of mindset of somebody gets harmed and they react and respond to that harm. And we're here to judge Mr. Mew for that reaction that he had in this setting that he did not set up. So what do we do as trained professionals who've had 732 days to contemplate what's the right response in a safe setting? I can't imagine a more difficult task. And I know I've heard Your Honor, if not other judges, say that sentencing is the most difficult task. But it's that measured response that I think we are required to give. In talking about the circumstances of the case, Judge, I do want to address just 4 points about the circumstance of the case, right? One of the things, is that's been talked about in the PSI, as well as in statements today, as well as in arguments today, is, walk away. I understand that, and I appreciate that. And I'm not trying to excuse, I'm trying to offer something that Gallion talks about is an ability to explain and articulate to Your Honor, so Your Honor might have a better understanding. And so I think the public can have a better understanding about what it is that created this situation. We know through the video that there was, Mr. Mew was walking away when some of the group of football players called him raper. And we know he responded to that. And I appreciate that the state's position is he should not have responded. He should have kept walking away. And I'm not trying to explicitly say disagree with that, but I'm trying to get so Your Honor might understand why a human being might respond to that. I think that those name calling, whether it's raper, whether it's pedophile, those are different than calling somebody a name that's specific to that person, right? That's just about not what they've done, but about their moral character. We've all heard the names, whether they start with an A or a B or a D or whatever it is. We've heard those names that I think lots of human beings have heard and they've walked away.
Any other letters?
When you're called something that says you have violated society's norms that I think we would all agree, everybody in this courtroom, that it's just, it's horrific, right? To be a raper, to be a pedophile who is preying upon somebody who's vulnerable. To be called that and to walk away might be seen as tacit agreement, right? Tacit agreement into those behaviors. And so I'm not saying everybody would, I'm not saying anybody should, but I can understand why somebody who's pro-social, who believes in community norms, might say, look, you can't call me that. You can't call other people that. You're breaking some norms about what you're saying, and I have to stand up to that to say, that's not okay. Not just the name calling, but that behavior that you accuse me of. It's not about the person, it's about those social norms. And that's something that I think you can't walk away of because you can't really say who cares. Somebody addresses you in that way, I think to walk away is to say who cares. And you know what? I do care. I would hope lots of people care. Lots of people would care if young, vulnerable people, children are sexually assaulted, women are raped. We should care. And a response to that kind of comment, I think, is, at its core, an expression of caring about that. That's why he turned around. It's not bad character. It wasn't an intent to harm. Then we come to the point where they talk about he should have walked away. And I get it. The 1 minute and 42 seconds into the video, he's standing, he's got the knife in his hand, there's two women in front of him, and there's other people that we can't see. I understand eventually we need to get to that 1 minute and 42 seconds into the video. But prior to that, the uncontested facts are he walks away twice. He did walk away. He walked away down the river to away from the group of football players that were tubing. And then he walked across the river to go over and talk to the other group of adults. He did walk away twice. Appreciate that the state's position is he should have walked away a third time. I understand that. But to say he didn't walk away, I think is inaccurate. And I think the record needs to show Mr. Mew always deserves to be sentenced upon an accurate record. He, in that situation, when he walked to the second time, as we've all seen in the video, he used his words. And it was shut down, and from then on, everybody has said he didn't use his words. That's what the state said. That's what some of the people who spoke today is he didn't use his words. I understand and appreciate that. As somebody who makes their living using my words, I appreciate the value in words. As somebody who listens to courts use words to solve problems, I appreciate the value in words. That's what he could be judged on, because he didn't use words. Why didn't he? We don't know. I think he said he was overwhelmed. He was afraid. He didn't know what to say. Could it be part of the language barrier? Could it have been other things? I don't know. But I think we need to put a pin in that. Use your words. What did he do then? Does the state say at the 1 minute and 42 second, he had a tool with him. We know he had a tool. It was a knife. And he opened up that tool and had it in his hand at 1:42. As the state said, he should have de-escalated it by showing the knife. I think that's worth mentioning because I think it's a tacit agreement, at least from a moral standpoint, if not just a legal standpoint and a factual standpoint, a moral standpoint, that that circumstance was perhaps worthy of a person showing a weapon. He didn't, but I think that's to understand the circumstances. I think that's essentially even if we disagree with it, we might understand why somebody in that position would take out their tool.
I would argue that sometimes showing a weapon is escalating.
He had a tool, and at the end of the day, he had a tool that nobody else had. He had a tool that nobody else had, and the manner in which he used that tool is why he's here. And I think the state's position is he used that tool harshly. Right? But, and I think this is the last point on the circumstances of this, but it's an undisputed fact. And he deserves to be sentenced on accurate facts. He did not use that tool until violence had been done to him. Should he have used the tool? The jury said no. Right? But I think in judging his actions and judging his character, that is something that I think you have to consider. He did not use that until it was used upon him. The appreciation obviously goes towards the PSI as well, right? The appreciation of the wrongfulness. And I say that because, as Your Honor knows, I'm not telling you anything, that there's an executive branch. The executive branch is represented by the district attorney's office, represented today by Mr. Anderson and Mr. Smeestad. Mr. Anderson spoke. That's the executive branch. As often happens in a judicial setting, the judge, as you did here, asks other parties of the executive branch to make a report. In this case, it was the Department of Corrections. They made out a report.
When this is done, we have a murder trial we're going to jump to.
I guess my position, what I submit to Your Honor, is there's a reason we put judges in charge of this and not the executive branch. Do not, I would submit to you, I would encourage you, try to persuade you, don't abdicate your authority to the executive branch. Don't abdicate your authority to a non-lawyer who doesn't have the same duties that a judge does. We all know judges have different duties. Gallion spells them out. There's all kinds of other things that I know I couldn't even list about the duties that a judge has that are different than a DOC agent, right? They're not bound by the law. They're not bound by Gallion. They're not bound by a process of reasoning. They're not bound by a logical rationale. And I say that because I'm going to submit here as an exhibit
Yes, we'll have it marked as exhibit number 1 in a moment.
Probably 2. I think the state had exhibit number 1.
2?
Thank you.
Exhibit
2. Your Honor probably knows, I hope, if not, for everybody to know, is the Department of Corrections has what we call a grid, right? They have sentencing recommendations for what should be recommended in the PSI for different cases. And it's a 9-box grid. You know, on the left is whether somebody's low risk, medium risk, or high risk. And across the top is whether the matter is mitigated, neutral, or aggravated. I'm going to use the term guidelines. They're not legal guidelines, all right? But it's certainly something that the DOC has. There's no mention of this anywhere within the PSI. Zero mention of this anywhere within the PSI.
I can almost read it.
Nor is there any number on this grid that is consistent with the numbers that were submitted by the PSI. For lack of a better term, they went off the grid. Absolutely went off the grid. In the recommendations to the Department of Corrections as to how to use that grid, right? There's different things about assessing the severity of offenses and whether or not something can be mitigated, neutral, or aggravated. And all of the guidelines talk about how if they're going to claim something is aggravated, they need to list the reasons why. Not quite as strong as Gallion to talk about a process of reasoning, or a rational, logical basis, but it does talk about that. And the Department of Corrections in no way justifies how they got to aggravated, if they did. I submit to you that this is mitigated. It's mitigated because it's reckless. It's mitigated because of the circumstances surrounding this that were not all of Mr. Mew's doing. And if you look at that box, if you look at the box where it says it's mitigated and it's lower risk, as Your Honor said, that's a blue box. And the blue box says no presumption of prison or probation. It's based on the circumstances. The number inside that box says 1 to 2 years. Very different numbers than what the PSI recommended, very different numbers than what the state recommended. But that's a process of reasoning. That's a rational, logical way to get to something. They, by they I mean the Department of Corrections, didn't follow their own rules and didn't explain it. The interesting thing for me in Galleon, when it talks about it needs to be an explainable sentence, it needs to be an explainable sentence. You need to be able to articulate it. And I don't know if this is my common experience with that, Judge, is I've been at times, despite perhaps my verbosity today and in other times, I can't always explain things. There's been times when I've had a conversation with my wife, who's, as you know, smarter than me, wiser than me, more thoughtful than me in so many ways. And we're talking about something and she'll be like, well, articulate the reasons why. Explain it to me. She'll even set me up sometimes where she'll give me time. And I can't. I can't. Whether it's dealing with our children, whether it's something else in the household, and she'll come back and be like, yeah, you can't because that's an intuition, because that's an emotion, and appreciate all of that. But at the end of the day, that's not how we, I think as human beings, if we're mature and developed, should be making decisions. And it's clearly not what Galleon says we should be doing. We need to be able to articulate it and explain it. And if you can't articulate it, if you can't explain it, that essentially means it's because it's not rational, it's not following a process of reasoning. And I say that because all too often, and I can't recall, I don't mean to project onto Your Honor if I've heard it from Your Honor, but all too often I've heard that there needs to be punishment. And I appreciate that. I appreciate the value of punishment, but punishment is not an objective in and of itself. Punishment on its own is not worthy. We don't want anyone in the world to punish other people without some sort of future objective. Punishment is a tool. It's a tool that we use to shape the future. But punishment can't justify itself. And so when I've been in court, again, no disrespect to Your Honor, I don't think I've heard it from Your Honor, but when I've been in court and I've heard judges say, well, there just needs to be punishment. That is contrary to Galleon. That is something that they can't explain. That is something that they can't articulate. Punishment in and of itself is not an end. Punishment is a means. And we know prison is punishment, right? We absolutely know that prison is punishment. That punishment, like I said, is not an objective. Punishment, if it's given, has to have a purpose. And because of the circumstances in this case, whatever that purpose is, I think it cannot, should not be vengeance. As I wrap up here, Judge, some of the things I want to tell you just are, we don't have the death penalty in the state of Wisconsin. But there are death penalty cases across the United States of America, in America. And in those death penalty cases, in general, we ask the jury to do a duty, right? And what the jury is used, the jury's duty in that sense is to give, quote, a reasoned moral response to the evidence about the offense and the offender. A reasoned moral response. A reasoned moral response is not vengeance. Apologize. So circling back to do not, I would encourage Your Honor, don't abdicate your authority to the executive branch. The executive branch and the judicial branch are very different. In many ways, maybe this is an oversimplification, but when I think of the executive branch, I think they speak about, that's who we are. This is my community. I live in St. Croix County. I've lived here for 28 years. And this is my government. And Mr. Anderson speaks for my government. He speaks for who we are in this moment. I get that. I might disagree with him, but it's different for the judge. I think judges in the judicial branch, right? Judges speak about who we ought to be. Not who we are, but to speak to everybody here about who we ought to be, right? There's a quote, if you will indulge me, that I have hanging in my office, painted on a wall. It's something that my wife gave to me. We have it in our home. Right? It's a quote from
Wife's been mentioned twice now.
German philosopher from, I think, the 17th century, Goethe. I have come to the frightening conclusion that I am the decisive element. It is my personal approach that creates the climate. It is my daily mood that makes the weather. I possess tremendous power to make life miserable or joyous. I can be a tool of torture or an instrument of inspiration.
He was right about the
I can humiliate or humor, hurt or heal. In all situations, it is my response that decides whether a crisis is escalated or de-escalated, and a person is humanized or dehumanized. If we treat people as they are, we make them worse.
He has this hanging on the wall.
If we treat people as they ought to be, we help them to become what they are capable of becoming. Now that's
a big wall. I was thinking it was like
incredibly
vinyl
profound
letters.
Quote, and I hope all of us at some point attempt to do that. We can't follow through all the time. That's an incredibly difficult task, especially here today, I have no doubt, Judge. But when we think of the judicial branch, we, not just Your Honor, the position, right? This is me as somebody who's been a participant, who went to law, who thinks of the law, the duty of the law. Judges, the judicial branch, we don't just want people who are smart. We want people with wisdom. We don't just want people who are thoughtful. I think we think of the judicial branch as someplace where there is measured. Not just analytical, but an understanding. Right? And I've seen Your Honor. Your Honor has shown wisdom, shown measured responses, shown understanding of other human beings. And I appreciate that today it's an incredibly difficult task that Your Honor has. But let me end with this. Your Honor is the only one here with a tool that nobody else has. Your Honor has the power to send another human being to be in a cage, to be in prison. We ask that whatever Your Honor decides today, that you are measured, you use your wisdom, that you are understanding, and that you perhaps craft a sentence that gives the community what they want, but also here under Galleon allows Mr. Mew the opportunity to get back out and live some period of his life, some time in which he can perhaps do some of the things of accountability that we talk about that I think are going to be more meaningful than a number. So, in the end, Judge, I appreciate that you have the tool of prison. Please use your words, not the tool.
Interesting.
Mr. Mew, this is your opportunity to make a statement or, if you wish, to offer any reason why I should not impose a sentence today. Would you like to make a statement?
Judge, he's written out a statement to me. I had it in hand. I printed it just for easier. I think he wants to read it, and then I'll submit it to the court, so it's just a part of the record.
Certainly. Mr. Bew.
Do you want to stand? You okay? Yeah. Read it to the court.
All right. Dear parents, family, and friends of Isaac, I would like to start by letting you know how deeply sorrowed I have been. I am, and I will always be, for the real fact that Isaac is not with you anymore, and that I was directly involved in his very tragic and unimaginable death at such an early age. I never meant for this tragedy to occur. My soul is broken. My heart is very heavy. And I will never be the same carrying such a heavy burden and sorrow. I pray to God for forgiveness, compassion, and love for everyone affected directly and indirectly by the outcome of this tragic event. I'm hoping that you appreciate how much I'm sorry for the outcome of those events. I'm very sorry.
So we'll have that marked as Exhibit 3, Judge.
That'll be received into the record.
That's all then from the defense, Judge.
Mr. Mew appears today in court for sentencing. Count 1 is first-degree reckless homicide, which is a Class B felony. With the dangerous weapon enhancer, the maximum possible penalty is 45 years of incarceration, initial confinement, and 20 years of extended supervision. On counts 2 through 5, Mr. Mew appears for sentencing on first-degree reckless endangerment, Class F felonies with the dangerous weapon enhancer. The maximum possible penalties are 12.5 years initial confinement and 5 years of extended supervision. Last, count 6 is battery. That is a misdemeanor. With the dangerous weapon enhancer, he faces a maximum possible sentence of 15 months. In preparation for today's sentencing, I reviewed a number of materials. First, I reviewed the pre-sentence investigation report prepared by the Department of Corrections. It's a 43-page report that provided me with information that I knew and information that I did not know about Mr. Mew, about his victims, families, about Mr. Mew's background, about all aspects of this case, many of which were talked about today. That PSI report also included a sentencing recommendation. I also reviewed Mr. Nelson's sentencing memorandum. It too was very helpful. It provided more information about Mr. Mew and his background, and I valued that information. Mr. Nelson submitted numerous letters from Mr. Mew's personal friends and coworkers. I read all of those. I also read the relevant portions of the file, including the complaint, the jury instructions, and the verdict. In a moment, I will pronounce a sentence that I believe is just and fair. When deciding on a sentence, I must consider the gravity of the offense, including the effect on the victims. I must consider Mr. Mew's character and his rehabilitative needs. I must consider the need to protect the public. The sentence must be based on the facts of the case and the law, not personal considerations, passions, or prejudices. But judges in Wisconsin have a great deal of discretion when imposing a sentence. Unlike many jurisdictions, we do not have sentencing guidelines or grids to follow. I want all of you to know that I have given this case a great deal of thought. I take my responsibility seriously. There is nothing more difficult or more solemn than imposing a sentence on another human being. As far as the gravity of the offense, the jury has spoken. Any efforts to relitigate this case are simply without merit. I firmly believe that the American criminal justice system is the best ever devised. It's not perfect, but I cannot think of a system of justice that is better at finding the truth while preserving the rights of the accused.
Did you watch the show this morning? Those were my words exactly.
In this case, 12 jurors reached a unanimous verdict. These 12 jurors were selected from a panel of more than 150 people. I, along with the attorneys for both sides, chose these jurors because they could be fair and impartial. The jurors came from all corners of our great county. They came from all walks of life. They were men, they were women, they were young, they were old. They listened to 8 days of intense trial testimony. They examined dozens of exhibits. They deliberated for 8 hours. In the end, they reached a unanimous verdict and found beyond a reasonable doubt that Mr. Mew was guilty of reckless homicide, reckless endangerment, and battery. Now, there are 2 key takeaways from this jury's verdict that I want to mention. First, the jury rejected the state's claim that Mr. Mew intended to kill Isaac Schumann or the surviving stabbing victims. In other words, the jury rejected the most serious crimes that would have sent Mr. Mew to prison for the rest of his life. Second, the jury rejected Mr. Mew's claims of self-defense. That means Mr. Mew did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or he did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. This jury found Mr. Mew guilty of reckless homicide and 4 counts of reckless endangerment. These crimes are serious. They mean that Mr. Mew did not think about the consequences of his behavior and that he showed utter disregard for life when he stabbed 5 people. For that, he will be held accountable, but the court sentence must reflect the reality that it was reckless conduct that the jury found him guilty of, not intentional conduct, which is punishable much more harshly.
It's a light sentence.
In weighing the gravity of the offense, I consider the impact these crimes have had on the victims. The battery to Madison Cohen was unjustified. While she did not suffer any permanent physical injuries, she has mentally suffered over this entire ordeal. She described to the PSI author the toll this case has taken and continues to take on her. This offense has devastated Isaac Schumann's parents and stepfather. No parent should have to endure the loss of a child. They have had to cope with the senseless death of a loved one while enduring the weight of the criminal justice system that can be slow, confusing, and sometimes frustrating to victims. To you and to your family, there are probably no words that I can say today that will alleviate your grief. But I would be remiss for not expressing my sincere condolences to all of you. I am sorry for your loss and what you've had to endure. Although it must have been difficult, I appreciate each of you speaking today and sharing a glimpse into Isaac's life and who he was. It sounds like he was a wonderful person, a bright young man who had an unlimited future. And for that, we in this community have lost. A.J. Martin and Riley Madison would have died on that riverbank had it not been for the swift action of law enforcement and EMTs and other tubers who helped to treat their wounds and stabilize their condition. They had long hospital stays, but they were very fortunate to receive high-quality medical treatment that restored their health. But we heard from them about the toll this matter has taken on their health, their mental psyche, and their prospects for the future. Anthony Carlson and Dante Carlson's wounds were less severe, but the risk to life was still present, obviously because the knife was directed into their torso near vital organs. But they fortunately have survived. Each of these surviving stabbing victims suffered permanent physical disfigurement, and that can't be overlooked. And we've heard from A.J. Martin just about how that disfigurement can affect one's life. In assessing Mr. Mew's character, I must consider his conduct on July 30. Mr. Mew's crimes were the product of circumstance, not intent. Mr. Mew was not looking to cause trouble or hurt anyone, but he made a series of very poor decisions. When confronted with words and boorish taunts and insults, Mr. Mew drew a knife and he struck Madison Cohen. That quickly culminated in senseless, lethal violence. He left the scene, leaving his victims to die, while casually floating past them and emergency workers as if nothing had happened. He nearly reached his car. He nearly escaped the jurisdiction before law enforcement arrested him. These are terrible acts that form an indelible stain on his character. There is more to Mr. Mew than his worst acts. I can tell Mr. Mew has taken this case very seriously. He has been appropriate and respectful in his demeanor in court. I sense that he carries a heavy burden, too. I imagine he is disheartened at the prospect of prison and the uncertainty of his future. But I also sense that Mr. Mew feels genuine sadness and remorse for what happened to his victims. I agree with the comments earlier that our criminal justice system is not designed in a way to allow people to apologize or to alleviate grief or to show respect to victims until a day like today at sentencing. That is unfortunate, but I heard Mr. Mew's words, both today and before, and I think he is sorry. Other than his conduct on July 30, Mr. Mew appears to be a quiet, nonviolent, peaceful man. He's never been in trouble before. He is loved by his family and friends. He's generous with his time. He helps others who are less fortunate or who are in need. Mr. Mew is respected in his community. Several of his personal friends and coworkers submitted letters that describe his character. Those letters were not shared in court today, but some of the most common words they use to describe Mr. Mew are kind, compassionate, friendly, loyal, respectful, and honest. Mr. Mew had to overcome great obstacles in life to achieve his place. He and his family suffered at the brutal hands of the communist regime in Romania. When he was a teenager, he and his family fled. They found asylum in the United States. Here he adjusted to a new country, new language, new culture. He got good grades in high school. He went on to college in South Dakota. He became an engineer. He worked hard. He had a successful career. I read somewhere in my materials that the proudest moment in Mr. Mew's life was becoming an American citizen. Mr. Mew has no rehabilitative needs. That means he doesn't need rehabilitation. He has no past criminal history. He does not associate with criminals. He has never used illegal drugs. He is not an alcoholic. He has not been diagnosed with a mental health condition, although there is evidence that he's experienced PTSD from July 30 while in the jail. Mr. Mew is educated. He has vocational skills. He has life skills. He's financially secure. He has a stable home. He has positive social supports. He knows the difference between right and wrong. He doesn't need rehabilitation. I mention all of these things to acknowledge that there is a lot more to Mr. Mew than what he did on July 30. I mention these things to recognize that a fair and just sentence takes into account the complete person, not just his worst acts at his lowest moment. Despite the seriousness of Mr. Mew's crimes, the evidence does not show that he poses an imminent risk to the public. Mr. Mew underwent a COMPASS assessment, which is an actuarial tool that measures a person's risk of committing future crimes. Not surprisingly, Mr. Mew scored low risk. He's not a career criminal. He's not a violent predator. Although Mr. Mew may not pose an imminent risk to the public does have a strong interest in holding people accountable who breach the social compact and commit crimes. It's the concept of punishment. Punishment is a sentencing objective. When a person commits a serious crime, that person forfeits rights enjoyed by the law-abiding community. The most restrictive punishments are reserved for those who commit the most serious crimes. The punishment exacts a toll on the offender because of the harm the offender caused to the victim and the community. Taking life and endangering the lives of others are two crimes that warrant significant punishment. Punishment for what Mr. Mew did, but also punishment that recognizes who he is and the circumstances of his crimes. Here, that punishment will involve the loss of liberty, because anything else would depreciate the seriousness of his crimes.
There will be jail time, but not much.
So at this time, I will impose the following sentence on Mr. Mew. For count 1, I will impose a term of initial confinement of 20 years, followed by 6 years of extended supervision. For count 2, involving Anthony Carlson, 5 years initial confinement, followed by 5 years of extended supervision. Count 3, involving Dante Carlson, 5 years of initial confinement, followed by 5 years of extended supervision. Count 4, Alexander Martin, 6 years of initial confinement, followed by 5 years of extended supervision. Count 5, Riley Madison, 5 years initial confinement, followed by 5 years of extended supervision. Count 6, Madison Cohen, 270 days of jail. Mr. Mew is not eligible for challenge incarceration program or the earned release program due to his age and the nature of these offenses. The sentences on all 6 counts will run concurrent. I am imposing a concurrent sentence because Mr. Mew's conduct toward each of his victims was part of a single continuous act over a short period of time. The periods of confinement take into consideration Mr. Mew's entire behavior, not just the behavior directed at any one particular individual. The conditions of extended supervision will include the following: maintain absolute sobriety, no possession of drugs or alcohol. You shall not enter any establishment where the primary purpose is the sale of alcohol. This will include places like bars, taverns, liquor stores, beer tents, and the like. You must complete an AODA assessment. He must comply with all recommendations of the Compass Assessment and the Department of Corrections. He must pay court costs and DNA surcharge on each count. He must submit a DNA sample. He may not have any contact with Isaac Schumann's family, including Elena and Donnie Hernandez and Scott Schumann. He may not have contact with Alexander Martin, Riley Madison, Anthony Carlson, Dante Carlson, or Madison Cohen. He is responsible for restitution. The state must submit its restitution demand within 30 days. The defense may have 30 days thereafter to object. If there is an objection, the matter will be scheduled for a restitution hearing. Because Mr. Mew is convicted of serious felonies, he may not possess firearms. He may not possess body armor. He may not vote or hold public office until his civil rights are restored. If he were to do any of those things contrary to law, he would subject himself to additional criminal penalties. If he violates the no contact orders, he may also subject himself to additional criminal penalties. Does the state agree on the credit calculation, 732 days?
Yes.
All right, 732 days credit. Mr. Mew is remanded to the custody of the sheriff for delivery to the Dodge Reception Center. Is there anything else for today, Mr. Anderson?
No.
Mr. Nelson?
No, Judge.
All right. Thank you all. We stand adjourned.
Wow, a 20-year sentence. It's all concurrent, so all the shorter sentences will expire before he is let out. But 20 years was the maximum sentence. I don't know how long of that 20 he will serve before he's eligible for parole. He does have 2 years of credit, which takes it down to 19. Wow. I was expecting a lighter sentence, but the state, in comparison, the state was asking for 70 and serving consecutive. So instead, that he got 20 years, and it's concurrent. But, well, yeah, he got 18 years because he got 2 years of did I say 19? 20 minus 2, 18. 18 years left, and I believe, so maybe 8 years. Does he serve half before he gets opportunity for parole? I can't math. I didn't come here to math. Tumwater Troy. I didn't. Tough case. Hey, Mrs. R.A., you're alive. How you doing? We are going to jump. I know we've been jumping back and forth from a lot of different courts. We're not going back to Young Thug. We're now going down to Judge Boyd's courtroom. She'll give me just 1 minute. We're going to be a little bit on a speed watch trying to catch up because she had a murder trial, a jury trial taking place right now in her courtroom that we want to jump to and begin. Let's see. We have we're going to speed trial to try to catch up. Might have to work through lunch. Hope you guys don't mind. Hang on one second. It's not letting me speed trial, so just 1 second. Speed 1.25. There we go. All right, let's jump down to Judge Boyd in San Antonio, Texas. Remember the Alamo? It's right there on the wall. And for this case, let me recall the name of this case. Just 1 second. Let's see, this one is...
All right, court is calling 2022 CR 11862, State of Texas versus Alexander Castro. Can I have parties announced for the record, please, for the state?
Alexander Castro.
And for the defense?
Gary Hillier and Jasmine Olguin for Mr. Castro.
And are you Mr. Castro?
Mr. Castro.
All right. Is there anything anyone wanted to discuss before the jury's brought in?
Very briefly, Judge, if
Yes.
I may. Your Honor, I just wanted to, I think we might have done it yesterday, but it's a long day. Just want to make sure for the purpose of protecting the record that my running objection to the makeup of the jury panel is overruled for the rest of the trial. I don't have to make it again.
Oh, well, the record will reflect what it reflects, counsel.
Oh, okay, Judge. Well, in that case, then I'll better do it again. I just want to make sure that the record shows that we object to the panel as seated because for the reason stated yesterday, juror number 20, panel member number 24, I tried to strike her for cause because she's a clerk in this court and she'd seen documents in this case which we believe is improper. She was not struck for cause and we had to use a peremptory strike on her. I asked for an extra peremptory, which the court denied. And then we had to strike another juror who made it. Well, we didn't get to strike a juror who made it onto the panel. I believe that was juror number 31. And the reason we would have struck him was because he was involved in a rear end accident where he was injured and his mother was injured. And that's why. And so we would like a record to reflect we want to run an objection to the panel so I don't have to make it again. Please, Your Honor.
Okay. I mean, the record is what it is.
I've made
yes.
it. So is it,
all right.
Judge, can I have a ruling on that, please? Just for the record.
Well, I previously ruled. Yes, I previously ruled on it, counsel.
Right.
But what I can tell you is that both the state and defense agreed that the panel member that you had an objection to, the items that panel member would have seen was the indictment. The indictment is going to be read to the jury. The other item that the panel member may have seen was the fact that your client is on bond. And usually counsels who are representing clients, what they don't want someone to know is that their client is in custody.
That's correct, Judge. That document she'd seen. Yeah, I don't disagree with
All right, see, you say that in other documents, but both parties agreed that she had seen perhaps two documents, the fact that he was on bond and the fact that she's seen an indictment in this case and that she's only been in this court since May. So we're going to bring the jurors in.
And the last thing is, Your Honor, we're going to invoke the rule after opening. And
just invoke it.
Yeah, okay, Judge. We invoke the rule then, Your Honor. And we just want to check with the state that we are, I don't know what order they're bringing their witnesses in, Judge, so that we don't have to, so I'm not disturbing the court's flow of trial. If Officer Morgan is first, if he's coming, I don't know. We would like a Jackson versus Deno hearing outside the presence with him. When Detective Martinez comes.
All right, so this is what we'll do. The state is going to call their witnesses. And then guess what? If either one of you all need the jury to step outside because we need to have a hearing, just approach, just tell me, Judge, may we approach?
Go ahead, Judge.
And I will know that means that you all want the jury to be excused. I will excuse them and we will have the hearing.
I can do that, Judge.
All right.
Thank you.
All right, let's bring the jurors in.
All right, for the jury.
If you will bring the jury.
Is this too fast, or do you want us to slow it down? We can slow it down and skip lunch. I do love the British accent. It's wonderful, and all the Brits are like,
all right, everyone, please be seated.
Finally.
I hope that everyone was able to find a parking space in the parking garage. All right, and remember my previous instructions. If you ever need a break, just do the break sign and we will see it. And also, if you're ever having trouble where you can't hear what the witnesses are saying or the questions that are being asked, just raise your hand and let us know because both parties want you to be able to hear everything. All right? So y'all were given an oath downstairs, and that was a general oath, but I need to give you an oath for this specific case. So if each of you will raise your right hand for me, please. Do each of you solemnly swear and affirm in the case of the state versus Alexander Castro, you will a true verdict render according to the law and evidence, so help you God?
Yes.
All right, you can lower your hand. State.
Yes, Your Honor. In the name and by the authority of the state of Texas, the grand jury of Bear County, state of Texas, duly organized and paneled and sworn as such at November term AD 2022 of the 175th District Court of said county and said court at said term, do present in and to said court that in the county and state of aforesaid and inferior to the presentment of this indictment, on or about the 22nd day of July 2022, Alexander Castro did recklessly cause the death of an individual, namely Alexandria Seibert, hereinafter referred to as the plaintiff, by driving and operating a motor vehicle at a speed that was not reasonable and prudent under the circumstances then existing, failing to keep a proper lookout, failing to apply brakes in a timely manner, failing to take a proper and necessary evasive action to avoid colliding with another motor vehicle, failing to maintain a proper following distance, operating a motor vehicle after consuming alcohol, operating a motor vehicle while impaired by reason of the introduction of alcohol into the body, and said acts and omissions resulted in the motor vehicle driven and operated by the defendant colliding into a motor vehicle occupied by the department. Deadly weapon allegation, and it is further presented into said court that the defendant did use and exhibit a deadly weapon, to wit, a motor vehicle that in the manner of use and intended use is capable of causing death and serious bodily injury during the commission of this offense against the peace and dignity of the state. Signed, jury, the foreman of the grand jury.
That's the
So
indictment.
that, how do you plead?
Not guilty.
All right, thank you. State, do you have any opening statements?
This is a DUI crash
All right, you may
that caused
proceed.
a fatality.
On July 22nd of 2022, Alexandria Seibert was heading home. She had just spent the day with her boyfriend, Josh. They went golfing, they went out to dinner, they went back to Josh's apartment and watched a movie. Her home was her parents' house. In order to get there, she had to go north on 281. While she was on 281, she ran into traffic. Traffic as far as the eye could see. You're going to hear from Officer Morgan. He's a 3-year San Antonio Police Department officer. He was responding to the cause of the traffic. It was a car crash that happened further north on 281. Now, while responding to this car crash, Officer Morgan was notified of another car crash. It happened further south on 281. He was in his patrol vehicle. He got out and he started walking over. But then he started running because he saw several cars that were very damaged. He ended up talking to 2 of the drivers of those damaged cars. One of those drivers was the defendant, Alexander Castro. Now, while talking to the defendant, Officer Morgan noticed a third vehicle that had been heavily damaged. It was a little further south. He ran. Inside that car was Alexandra Seibert. She was unconscious. She had an open head wound. She was bleeding heavily. She never woke up from that. EMS came and took her to University Hospital, and Officer Morgan began his part of the investigation. Now, Officer Morgan's a patrol officer. Whenever there's a potentially fatal crash, patrol officers have to call SAPD's Traffic Investigation Division. They're the experts when it comes to car crashes. They can recreate, they can figure out how this happened. Officer Morgan didn't have any eyewitnesses who could directly say exactly what happened. So all of the drivers that were involved were kept at the scene so that they can talk to TID. But Officer Morgan made a mistake. TID told him to follow up. He didn't. While conducting his investigation, he spoke with the defendant several times. You're going to hear that. He asked why things happened. You're going to hear what the defendant had to say. TID eventually realized that there was no follow-up. So several hours after, they made the scene, spoke to the drivers, and began their investigation. You're going to hear from several of the witnesses, several of the people who were on the highway when this happened. They did not see what happened. One of the witnesses was involved. His car was half crushed in due to the defendant's car hitting him at a high speed. You're going to hear from several 911 callers who saw the traffic, who saw the long line, and decided to exit because that's how far away you could see this. They had enough time to exit. One of the 911 callers saw the defendant's vehicle speed down 281, approaching all the cars that were waiting there in traffic. He didn't see the accident. He saw the debris fly in the air. He heard the actual crash. You're going to hear from now Sergeant Martinez. She was a detective at the time with TID. She was the primary detective that was investigating this case. She looked at the roadway evidence. She looked at data from both Alexandra's car and the defendant's car. And she was able to calculate and figure out exactly how fast the defendant was going. He was going over 90 miles per hour. He never hit his brakes. He never made any attempt to avoid any of the cars that were so vulnerable there. State's asking you to listen to the evidence. Just think about what we're presenting. Officer Morgan was disciplined for what happened, for not following up. He was also disciplined for not further investigating. And you'll hear from him why that happened, what happened there. But don't let that failure on Officer Morgan's part cloud you and how reckless the defendant's actions were. So the state's asking you, again, to listen and to judge how reckless his actions were that night.
Defense, any opening statements?
May I proceed?
Yes.
Thank you, Judge. Oh, yeah.
Fortunately, he's away from the mic. It might be hard to hear his opening statement. I'll do my best with the audio. He's, I guess we're playing Pictionary. 3 words.
You guys want to see that?
Sounds like.
You want me to see that?
No. Okay. And state and all attorneys, please feel free to move about the courtroom if you are unable to view an item.
Thank you, Judge. This case is a tragedy. It's a tragedy. We have to acknowledge that up front. It is a tragedy. And Alexandra Saber lost her life as a result of this tragedy. But this tragedy is not a crime. And I'm going to tell you why it's not a crime. And I can agree with some things that Mr. Escobar said, but I disagree with others. I'm going to tell you the whole story about what happened that night. Because I tell you what, I didn't mention that name. Shayna Alassal. You're not going to hear her come as a witness. No criminal case filed against her. But Shayna Alassal is the first domino that caused this chain reaction where Alex drove into a scene of a crash. Shayna Alassal.
Third party.
You're going to see, evidence is going to show that Shayna Alassal argued with her husband. Shayna Alassal drank. Shayna Alassal drove the wrong way on Highway 281. She drove the wrong way up the exit ramp on 281 and had a collision with a vehicle. Shayna Alassal was driving the wrong way on the highway. But for the conduct of Shayna Alassal, the truth is, but for the conduct of Shayna Alassal, Alexandra Siebert wouldn't have been sitting on the highway, parked in that long line of traffic that Mr. Escobar talked about. Alexandra Siebert would still be here. She wouldn't have been sitting in the traffic, but for the conduct of Shayna Alassal. Now, she's not here. She wasn't arrested. Shayna Alassal was driven home to meet her husband that she'd argued with by the police. And I hope she's watching today. I hope she's watching and listening to this, because she's not here to answer for what she did that put that man in the chair there. Whoa. Where the state is trying to convict him of killing somebody. Now, was he driving too fast? Yes, but he was driving too fast on the right way, going the right way down the highway. So that's the first thing. The state talked about causation in the PowerPoint, in the voir dire. They said, but for the conduct of him. That's what they have to prove, but for the conduct of him, Alex. Miss Seibert would still be alive. But it's but for the conduct of her. But it's not just her. We're not just blaming Shayna Alassal, even though she did get drunk, drive the wrong way on the highway, have a collision, then get driven home by the police. Mr. Escobar talked about the police. Now, they do a difficult job. I used to be a police officer. Dealing with a scene like that is difficult, but they have got a responsibility. The police officers at the scene are the second domino in this chain of events that leads to the unfortunate death of Miss Seibert, because they've got a duty to protect. They've got a duty to warn. And like Mr. Escobar said, they were on scene for approximately, the evidence is going to show, the officers were on the scene for 22 minutes before there was another accident. On the highway, they put out no flares. Everybody's seen an accident on the highway where the police put out flares. They didn't put a police vehicle in the way. They didn't call one of their buddies on the radio to say, hey, man, can you go and protect the scene? There's some flashing lights so people don't crash into them. Any of that. No one put on a luminous bright green jacket to say, hey, slow down, slow down. No one did any of that. Now we talk about the definition of recklessness. That's what Alex is charged with. What the police officers did at the scene is the definition of recklessness. It just is. It's the truth. Because you've got to know about a risk. You've got to know about a risk, and then you've got to consciously disregard it. How do we know the officers consciously disregarded a risk that they know about? It's in their policy and procedure manual. And you're going to hear it from the sergeant who used to be a detective. It's one of the basic policies that the police have. One of the first things they do is warn. You go to a scene of an accident and you warn. You make it safe. They didn't do that. They just got focused in on the first accident while traffic was building up, building up, building up, building up, building up, building up for 20 minutes. Now, he might have been driving too fast, but he was driving the right way on the highway. Shayna Alassal wasn't. She's the first but for. The officers are the second but for. Now, let's talk about Alex.
We've got two buts for.
Alex. I'm talking about Alex Castro. Talk about him. And it's going to happen throughout this trial. And I want you to watch out for it, please. State is trying to turn this into an intoxication manslaughter case. And it's not. He was out for 8 hours before this accident. And you're going to hear from him. You're going to hear from him on the videos talking to the officers. He said, I had 4 beers earlier, man, at the driving range. 8 hours before this happened. They're trying to turn this into an intoxication manslaughter case, and it's not. And they're trying to do that because recklessness is presumed, and they can't prove it. Don't let them do it. It is not. Don't let them play on your emotions so that you turn it into that. It's not. He's got to be judged on whether he was reckless or not. What does reckless mean? Remember what we said about reckless. Reckless is you know of a risk. You know of a risk, and then you say, no, I consciously disregard it, which means I know that traffic is stopped. Traffic is at a standstill in front of me. And this is where we're going to ask you, this is why we picked you guys. This is why I'm glad you're on the jury, because we're going to ask you to use your common sense when you look at this evidence, because apply your common sense to this. What the state is saying in this charge, this is why he has to be not guilty, because they're saying that he knows that there's this risk, but he disregards it. So they're saying that he's driving, the state's just said in opening that he's approximately driving 90 miles an hour. He's driving too fast the right way down the highway. So if he's disregarded the risk that he knows is ahead, remember, they've got to prove, and you swore an oath a minute ago. The judge gave you the oath. You swore to follow the law and the evidence. This is the last thing I'm going to leave you with. If you follow that oath, you've got to swear to follow the oath, to look at the law, which is that Alex Castro was aware of a risk and he consciously disregarded it. It doesn't make any sense, because you're saying, this prosecutor's saying he's doing 90 miles an hour and he's driving into a brick wall, because that's what they're saying. That's what recklessness is in this case. He is driving 90 miles an hour, according to the prosecutor, into a brick wall. That can't be the case. It makes no sense, because that means that's suicide. That's tantamount to him trying to kill himself. Common sense says that. If you are driving at the speed Mr. Escobar says he is, and you're driving into parked traffic, you're trying to kill yourself.
Finally an objection.
You're trying to kill yourself.
Sustained.
And that defies common sense. You see, I'm right. That's why he was objecting.
Whoa! All right. Number one, the objection is sustained. Ladies and gentlemen of the jury, that's an improper argument. These are opening statements. Both parties are to inform you of what they expect the evidence to show you. And state your objection is sustained.
Yeah, this has been a closing argument instead of opening statements. This is nuts.
So I want you to think about why this happened. Why this happened? Because there's only one person sitting in that chair today, and he's not the only one responsible for this. His actions are by definition not reckless. If anything, he ought to have known. He ought to have known. But to say that he knew and then he disregarded it means he's driving into a brick wall at 90 miles an hour. That makes no sense. Shana Lasso's the first domino. The police officers are the second in their investigation, failing to warn, failing to do anything to protect Alexandra Siebert. And she's a good person. I never met her. I've seen a lot of evidence about her. She did nothing wrong. It's a tragic thing. And you're going to hear, and it's
sustained.
Judge, it's opening statement. It is open.
All right. Oh, counsel. When I make my ruling, those are my rulings. So the objection is sustained.
Thank you, Judge. I'm sorry. The evidence that you're going to see, the evidence will show that this is heartbreaking. You're going to see things. You're going to see things. I want you to be prepared for that. You're going to see things that are going to break your heart. They are. It's going to hurt your heart when you see it. It is. But remember these dominoes. Go back to the law. The state is going to try and make you see these vehicles outside. The evidence is going to show. The state is going to show you these vehicles outside in the parking lot. It's just the truth. And it's going to be shocking. I'm going to tell you now. It's going to be shocking. And it's going to hurt your heart. But please use your common sense. Please follow the law. Because, you know, the first domino in this case is Shana Lasso. She's not here. She was driven home by the police after driving drunk the wrong way down the highway. The second domino in this case is the police failing to warn anyone. And the third one is the only one that they've got. He's sitting here, is Alex Castro. And he's not negligent. He's not reckless. If anything, he's negligent.
Sustained.
Okay, we're going to
ask you to find him not guilty. Thank you.
All right, thank you.
Oh my
All right,
goodness.
ladies and gentlemen, I'm just going to have you all step outside in the hallway. Just give me 2 minutes, okay?
Well,
all right, everyone, please rise for the jurors.
Attorney, the whooping he's about to receive. Oh my goodness. Love the accent. Love the accent. This guy, that was not an opening statement. If anything, that was a closing. That was a closing argument. That was not an opening statement, and he just pushed through. And when there was an objection, he's like, they're objecting because they know I'm right.
All right, everyone, please be seated.
Except for you, attorney. Come up here and get the paddling you deserve.
All right. So this is what I want to tell both sides. I understand sometimes passions run high and that everyone is trying to advocate their side. But this is what is not going to happen. And I want people to hear me and internalize what I'm saying. Number one, there are going to be legal objections. I'm going to hear the legal objection and I'm going to make my ruling. And once I make my ruling on the legal objection, there is not going to be a comeback at me that is a response that is not legal. So counsel, this whole thing where the state is objecting, saying it's argumentative, and I rule on it, the comeback answer is, no, it's not argumentative, Judge. It's like, everyone, keep your levels here, make your objections, I will rule on them. Once I rule on the objection, guess what? That's my ruling. Unless you have something new for me to hear, that's my ruling. And if you feel that my ruling is not correct, then that's what the Court of Appeals are for. That's what the Fourth Court is for, the 13th Supreme Court, wherever you want to take it. But I will tell you what I've discovered in my experience trying both as a prosecutor and a defense attorney. The jurors just want to be here. They want to hear what the story is and hear what the facts is. But if there's this back and forth where people are tending to get into the point where it's disrespectful, then we're going to be in a different place and I'm going to respond differently. So in this court, I like everyone to treat everybody with kindness and respect, because that's the way you don't have tempers flaring. Because all the cases in felony court, these are very serious cases where potentially sometimes people are looking at prison. You have complainants' families who may be upset. I don't want their tempers to flare. You have the accused families who may feel like, you know, their family member, their loved one should not be here. So they have tempers as well. So I'm depending on attorneys. You're all professional. You should keep it here. Does everyone understand?
Yes, Your Honor. Yes, Your Honor.
Yes, Judge.
All right. So the rule has been invoked. So state, if you can make sure that your witnesses know the rule has been invoked. So if there's anyone who's in the courtroom for the state or the defense who's planning on testifying, now's the time where you can no longer be in this courtroom. They've done their opening statements. Witnesses are going to be called. And if people who are planning on testifying view anything or in the courtroom or talk to people about testimony that they've heard, what's going to end up happening if it's discovered, I will probably end up hearing motions from either the state or the defense asking that someone not be allowed to testify. Does everyone understand?
Yes, Your Honor.
Yes, Your Honor.
All right. The other housekeeping matter, again, if people are putting things on easels, if people are taking papers to people, defense attorney, state attorney, if y'all need to move around to see it, you don't have to ask permission. You don't have to ask permission to approach a witness. But remember, when you approach the witness, after you have finished approaching the witness, which whatever you want them to see, please have a seat. All right. And Laura Metzel, did you have something for me to sign? All right. I'm going to take this up. Then we're going to bring the jury back in. Yes.
Just one other preliminary matter. That Barbara West is the mother of the victim, Alan, and she is in the courtroom. She's not a material witness, but she may be brought in for punishment purposes if we get the punishment phase. I'd ask for her to be excused from this rule.
Judge, can we approach?
Do they have a Marcy's
Oh,
law?
I mean, either you want her, let's go on the record. All right, state, you're asking who be excused from the rule?
Barbara West, she is the mother of the victim. She was not at the scene. She didn't arrive at the scene, nor does she have any knowledge of what happened at the scene as an eyewitness account. She is solely the mother of the victim in this case, and she may be brought in for punishment purposes and not the first phase of this trial, Your Honor.
All right.
Judge, can't agree to that. We would like to invoke the rule. I can't tell the state how to try their case. They could use other people. So we're invoking the rule, please, Your Honor.
All right. Your witness is allowed to say she's not testing in the first phase of the trial?
That's right.
All right. She's allowed to say.
Well, Your Honor, in that case, based on the court's ruling, can Mr. Castro's parents come in because they're only anticipated to be punishment witnesses if we get there, and I've just told them to leave.
All right. Do you have any objections, state?
No.
All right. The state is saying that they have no objections to his parents being allowed in the room because they're only going to testify in punishment if we get there. Is that correct?
Correct, Judge.
All right. So do you still have an objection to the complainant's mother being present?
Well, the court's already ruled, Judge. I'm going off. Yes, I do, Judge, but I'm going on the court's ruling. I'm not waiving that objection, Judge.
No. Here's the thing. I'm just asking questions.
Yeah, I maintain my objection. I respect the court's ruling.
All right.
I don't get them to come in then, Judge.
All right. They can come in.
Wow. So he would not allow the mother of the victim in, or defense
All right.
did not want the mother of the victim in, but he did. So we objected to that, but he does want the parents of the defendant in. I'm surprised when the state showed that that courtesy to him that he didn't drop his objection to the mother of the victim.
And state and defense, we'll talk about the vehicles.
It's going to be
I'm going to see where we end up in trial today. And then we'll talk about when specifically the vehicle should be here.
Okay.
All right. All right, let's bring the jurors in.
All rise for the jury.
Oh, that was loud. All rise for the jury.
If you will bring the jury.
Defendant is in the blue jacket on the far right side of the screen, just above the objection counter, which is up to 6 so far. And this should say 7 because he objected to the mom staying there. It might be a high count for a short trial. This is day 1.
All right, everyone, please
I don't
be
know how many
seated.
days it's slated for, though. Not long.
State,
Maybe
you may
just
call
this
your
week.
first witness.
Your Honor, the state called Officer Jeremy Morgan.
Officer Jeremy Morgan is the first witness.
Your Honor, may we approach very briefly?
Yes. Yes.
She's killed the mics, so we just get to admire the fine workmanship.
Well, we'll cross that bridge when we get to it. Okay. All right. Thank you. All right. Thank you.
Attorney's
All right,
tie
thank
is
you.
crooked, and I can't unsee that.
Hello.
Nice suit, both of them. This is a car
Can you
crash.
raise your right hand for me,
death
please?
Trial.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, Your Honor.
All right. You can lower your hand. Please state your name for the record and spell it.
First name's Jeremy, Jeremy. Last name's Morgan, Morgan.
All right. And if you'll make sure that you keep your voice up so that members of the jury can hear,
Yes, ma'am.
and the court reporter.
Yes, ma'am.
All right. State, you may proceed.
Officer Morgan, who do you currently work for?
I work for the San Antonio Police Department.
How long have you worked for San Antonio?
I've been employed with them for over 5 years.
What type of training did you receive to become a San Antonio Police Department officer?
Went through 8 months of rigorous training from April of 2019 to November of 2019.
And during this training, what did you learn about in order to become a police officer? What sort of subjects?
Learned various things ranging from tactics, penal code, traffic code, safety, how to de-escalate.
So what unit are you currently assigned to?
Currently assigned to North Patrol.
North Patrol, what area does that cover?
It covers as far south as Patricia and as far north all the way to Comal County.
And what are your duties as a patrol officer?
My duties are to respond to calls for services and ensure the safety for the public.
And were you working on July 22nd, 2022?
Yes, sir.
Now, what shift were you working on that day?
I was working power shift.
What does that mean?
That shift rate starts at 5 o'clock in the afternoon and goes all the way to 3 o'clock in the morning the following day.
And on July 22nd, 2022, in the morning hours, did you have to respond to a call?
Yes, sir.
What call did you respond to?
Respond to a major accident at 281 and TPC Parkway.
You're on man approach?
Yes.
Mr. Morgan, I'm going to show you what's been marked as State's Exhibit Number 1. I want you to take a look and see, do you recognize this?
I do recognize it.
What is it?
That is a copy of my co-band video.
And is it a true and accurate depiction of the video that your co-ban captured on that day?
Yes, sir.
Has it been altered or amended in any way?
No, sir.
Your Honor, state what offer states Exhibit 1 into evidence.
Yes.
No objection.
All right. State's Exhibit Number 1 is admitted without objection. Granted.
Later, we are going to get a witness camera eventually, but sometimes she leaves it off for a while. I don't know why. This started this morning, so we're a little behind, but we're loving this.
No, that one.
Another one. Corner.
Right hand side?
Right hand side, sorry. Oh, this one.
I don't know who sent me these paddles. They just arrived without a letter. So whoever sent me the yes/no paddles, please know that I appreciate it. Thank you very much.
Officer Morgan, what are we seeing here?
See me driving northbound 281.
And roughly what area are we in?
We are in the Evans Stone Oak area.
And what area of of San Antonio is this on?
This is on the far north side.
And is this in Bear County?
Yes, sir.
And so looking at the video, what are you approaching?
I'm approaching the exit ramp for Marshall Road.
And where was the accident you were responding to?
We were dispatched at 281 at TPC. Upon arriving on scene, we found that the crash was further north, right at the edge of the exit ramp for Marshall Road.
And what are we seeing up ahead on the highway in Coban?
Stop traffic.
How can you tell it's stop traffic?
Brake lights, vehicles are not moving.
And what do you do after you arrive at the scene?
I tried to make my way through, but knowing that I can't fit my patrol vehicle through there, even I split the cars, I decided to exit my vehicle and to assess what I had up ahead.
Approaching with what's been marked as State Exhibit number 2. Do you recognize this?
Yes, sir.
What is this?
It's a copy of my body camera.
Okay. And other than redactions for legal reasons, has it been altered in any way?
No, sir.
And again, it's a true copy of what happened that day.
Yes, sir.
Your Honor, state what offer State's Exhibit number 2.
Yes. Any objection?
Wendy, thank you very much. I will check the
Have you
package again. I
seen
did not see
State's
the gift
Exhibit number 2
message.
in its entirety?
There was an objection?
All right. How long is this? No, with regards to its hearing, how long is the video? All right, step back. Ladies and gentlemen, there's something I need to take outside your presence. I'm going to have you all come back. I'm going to say 10:30. It may be sooner than 10:30. You've heard some evidence in this case. You're not allowed to start internally thinking about this case outside this courtroom. You are not allowed to view anything about this case. You are not allowed to do any investigation. You are not even allowed to talk to each other about what you've seen so far in this courtroom. So you're not allowed. Do not think about this case unless you are in this courtroom and you're listening to what's being presented. Does everyone understand?
Yes.
All right, so I'm going to have you all back at 10:30. Everyone, please rise for the jurors.
Yeah, that would be a hard instruction to follow. Judge, I tried not to think about the thing you told me not to think about, but while I walked out, I started thinking about it. And so I guess I can't serve as a juror because I couldn't stop thinking about it. This is a juicy trial, very spicy attorney, British, love the accent. I've heard somebody say Essex is the type of
Defense, you have objections to State's Exhibit number 2. Have you had a chance to view it?
No, I haven't, Your Honor.
All right, State, if you'll play it so that defense counsel can see the redacted version.
Yes, Judge.
And so if you would like to walk around, you're more than welcome to walk around. We're taking a short break for them to view the video. Just remember you're under oath and the rule has been invoked. You're not allowed to discuss your testimony with anyone except for attorneys for the state and the defense. Do you understand? All right, you may step down. You're welcome.
I think we need a soundbite out of this morning's exchange. during the opening statements. 2 TV cameras on the backside also recording this. I'll have to check and see if any of those are streamed that might give us more pictures. Let me do some research on my end here really quickly, because I'd love to get those additional feeds. I've heard there's a JAC response to Sarah Boone's filings. I haven't looked at that yet. We did go over the filings a little bit where she asks for unspecified. Hey, there's the camera. Thank you, Deputy. We got the witness cam turned on. Let's see how I can make this work. This is going to be...
over there. Yeah, I ate my brakes and everybody stopped fingers. I couldn't talk about that. Oh, there's another car. Alright, I got EMS coming to take you out. So bear with me.
Your Honor, that's one portion. There's about 4 of them.
Oh, no, he has an objection to his client's statement. So wherever his client's statement is, please play it. And we'll see, defense, if you still have objections.
Thank you, Judge.
So pause it for one moment. If you'll pause for one moment. So the first statement, defense, where the officer has made contact with, I'm making an assumption that it's your client. Do you have any objections to that first part?
Judge, I'm not sure. Could we play it again very briefly?
All right.
And what's up in EMS? What's up, man? I'm okay. What happened? Yeah, we have another accident over there. Yeah, I ate my brakes and everybody stopped fingers. I couldn't talk about that.
Sounds like he's throwing his words.
Alright, I got EMS coming to check you out. So bear with me.
All right, pause.
No objection to that, Judge.
All right, so defense has no objection to that statement. If you can move on to the next statement that's made.
Okay. So, you the driver of this one? Yeah, you got the license on you? Yeah. Yes, sir. Can you hear me? I'll hold up to the sanitation. This one is correct. What happened? Everybody hit the brakes on some of the brakes, and it just, I couldn't. I tried to, I hit the brakes. Okay. Who'd you hit? You hit him? No.
And then from there, Judge, that's that second portion.
All right, any objection to the second statement?
No objection, Judge. It's not his. Yeah, play it.
Oh, you're good. So it might be a good minute for you to be out here. We're waiting for our investigative unit to come out here. Get to see what happened. That's for you. So at the top, it's going to be labeled as crashes right now. Case number's right there for your insurance purposes. And it's all of you that's coming out of the traffic investigations department. They'll come out here and ask you what happened. Do you recall what happened? Like, this traffic came to a stop?
I just remember everything came to a stop and I hit the brakes. And I just kept on the brakes and I kept seeing brake lights and everything just.
Do you know when you hit? Like, did you hit it? You hit the 18 wheeler?
Thought I hit him, yeah.
No, you hit it down.
He said I hit him, but I don't know what I flipped on. I know I flipped.
You like rolled or like spun?
I know I rolled. I mean, you can see the scratches all on the side of the truck.
Yeah, I can see the scratches. I guess if you just roll like that, try to figure out what you might. You know,
I think the 18 wheeler hit him, and he stopped all of a sudden, and I just stopped, like, just tried as hard as I could to hit the brakes.
Yeah. Only a TPC, because that's the nearest exit. Because we can't have any more coming through here right now. Your truck's stuck here for a little bit.
I'm just wondering because my wife's coming.
Yeah, if your wife wants to chill in the parking lot over there, that's yeah. Because like I said, it's gonna be a good minute. And we can always give you a courtesy right off the highway. You got any other questions?
I really just want to know what happened. All I know is everybody hit the brakes and I hit the brakes and just didn't stop.
Yeah.
We're all going with traffic. We're all going to I know more brake.
Okay, any objections? Keeps going on.
Picture or not. I mean, I can hold, I don't know how much experience there's going to catch
I have full coverage. I'm not worried about that. I'm just
trying to figure out what's going on. You and me both. So,
That's the third portion is kind of broken up, Judge.
No objection to that, Judge.
All right.
But we have objection to everything after that, Your Honour. That's what the subject to the hearing we would like with.
All right, continue with the video.
Demo.
Yeah.
I spent a few months in Chelmsford, not far from Essex.
My car? I'm not gonna say anything. As long as it's not exposed over to the public over there. Yeah. Yeah, I got it. So if you just wanna like go out right here, you just wanna go for it. So what? My wife kept trying to. I know. Like I said, I can't stop other people from crashing their cars too. Earlier today. Yeah. Well, is it for work?
No, I feel like I'm a actually, it's really, I'm going to let them know about my feeling and my.
Okay. How long was that?
It was.
Oh wow, so kind of recent, then like 2 months ago.
It wasn't really an accident. They tried to steal my bike.
Oh, for where? We were trying to steal it over there.
Yeah, the ball. And one piece of like trying to just get off my body. But one guy grabbed my arm, that was my punch in. So I just hit it. And, I was wrong, but I hit a curve. And I just flipped over.
Oh, okay.
So I kind of saved myself, but
You say the bike at least?
yeah, bike fine.
That's good.
I've spent a lot, man. Like, I was on my way to pick up my boy. He's like, I need a ride. I'm like, I got. I was sitting softball over there on the
Blanco, Texas or Blanco Road? Oh, okay.
I didn't know where he was at. I was like, where you at? And I was like trying to put it in my. And that little Honda just like came into me and like flipped over me. And I was like,
What do you mean the Honda slid into you?
I don't know, it just came like into me. Like, I don't know. I wasn't paying attention to what she was doing. Or I didn't know it was her actually. So,
Yeah, so the driver was over there.
yeah, the driver was just like erratic and it just like came into me. And it took me over. And I was like,
Which lane were you driving in, you know?
I want to say I was in this lane. I was in the fast lane.
You were in the right hand lane? And she was driving erratic? Which way was she driving erratic on?
It was bouncing all over the place.
Talk about get the median or what? Talk about hitting like the median or something? Like,
I mean, I did. Like, I thought she pulled it over. And she came under me and I was on my side. There was nothing I could do. I was just like pulling on.
Which part under you are you talking about?
Just like she came and put it
On your right side or your left side?
on the right side.
But she came over and you on the right side.
From looking at it, I guess I went over her and stopped right there.
Yeah. So that caused you to roll over and
Yeah.
And so then you flipped for a good amount.
I was sliding.
Is he good?
I don't know. Pick a little bit of it was good. Well, I spent right there. Couldn't get home.
I hear you.
Dude, this is horrible. The 18 was, but Mike, he's gonna take off.
No, he's not taking off. He's just chilling. He can't take off with the vehicle yet. Because this is part of our crash. It's gotta stay, even with all the stuff he has in it. Because the idea at his destination. Yeah. You'll go surprise her here in a few, hopefully.
I'm ready to go.
Yeah.
I mean, this whole thing is horrible. But
Yeah, if I
I can fast forward through this sound.
Go on your way.
I thought like I just get like a first.
But I want to hear the
No, they
argument about
like to do
this.
their interviews, especially when it's on scene.
They want a Jackson Deno hearing, which usually has to do with whether this is a voluntary statement given by the defendant.
Yeah, I just want to stay with them.
This is body cam from the crime
So
scene.
we're watching
They're
him
talking
again?
about it.
That's the final portion, Judge.
All right, defense, you have objections?
Yeah, object to that, Judge. That was Mr. Castro was asked to leave several times, said that his wife is there to pick him up. He doesn't mind providing a statement, but the officer keeps questioning him. And under Jackson versus Deno, our position is that's a coercive involuntary statement because he's not allowed to leave. In effect, he's under arrest at this point. He's asked to leave. He said his wife's here. The officer says he can't even go to the restroom at this point. Yet they still detained him. And this is 2 hours after the accident. So he's been on the scene for 2 hours. He's not allowed to leave. In effect, he's under arrest. He's been told he can't leave. Yet the officer keeps questioning him. And it's coercive and it's overborne his will. No statement shouldn't come in and we object to him, Your Honor.
All right, state.
Your Honor, here, Mr. Castro has never put in handcuffs. He's never been in the back of a squad car. He's allowed to be on his cell phone. He's allowed to stand on the side of the highway. he is allowed to use the restroom. The officer is walking with him because it is a highway. At no point is he ever actually arrested. He's allowed to leave. At the end of this night, Mr. Castro is never actually arrested. There are also 2 other drivers that were there at the scene that were involved in this car crash that are also asked to stay and are told to stay so that they can talk to traffic investigators. So he's not put under any more coercive pressure than the other 2 drivers. So we're asking that the court rule that his statements are voluntary at this point.
May I briefly respond, Your Honor?
Yes.
Well, we don't actually know that. I understand Mr. Escobar's point, but we don't know that, do we? Because we haven't seen any of the evidence to do with Mr. Stefanov or the
All
driver.
right, so let me just tell everybody, the only person I am focused on is whether or not the statement by Mr. Castro followed the proper rules and the proper law. That's it.
Thank you, Judge. In that case, it didn't, because it's irrelevant what happened to the other drivers. They're not an accused in a criminal case. Mr. Castro is. That's why he's not allowed to leave, because, as we're going to see later on, they suspect him of, the officer makes comments on there about him hauling ass and stuff like that, excuse my language. But he's a suspect, he's a target of this investigation already, and he's not allowed to leave. And the court knows, right? I don't need to tell the court that handcuffs isn't the only measure of whether someone's arrested. In Texas, someone doesn't have to be told they're under arrest. It's whether their freedom of movement would make is impeded in such a way that a reasonable person under circumstances would believe that they are under arrest. At this point, he said, my wife's here, can I go? No, you can't. Can I use the bathroom? No. I've got a doctor's appointment in the morning because I had a motorcycle accident. No, you can't leave. You can't leave, you can't leave. He's under arrest, Judge. These statements can come in and we'll defer to the court. Thank you, Your Honor.
All right, thank you. Any other objections to this other than the statements?
Yes, Judge, it violates his 5th, 6th, and 14th Amendment rights under U.S. Constitution, Article 1, Section 10 of the Texas Constitution, and it violates 3822, and therefore it's 3823 of the Code of Criminal Procedure, Judge. Thank you.
All right.
Thank you, Judge.
Anything else?
No, Judge.
All right. And State, if you could do me a favor, if you could just play the part that he is saying that is on the video.
Yes, Judge. So we want to skip, I just want to be clear.
No, he's saying that there's a part in the video where Mr. Castro is asking to leave and he's being told that he cannot leave.
Judge, if it helps the court, the timestamp is 3:12:27, I think, on the Zulu time.
Okay.
Oh, no, it's not. It might be. That's where it starts.
I have at least a 14-year with gas.
What if I was in this lane? I was in the fast lane. You were in the right-hand lane? And she was driving erratic? Which way was she driving erratic on? She was bouncing all over. Come on, get median or what? Talking about hitting like the median or something? Like, I mean, I did. Like, I thought she pulled it over. And she came under me and I was just on my side. I don't know, I didn't know. I was like pulling on. Which part under you are you talking about? That's like she came and put on your right side or your left side? On the right side. Or she came over with you on the right side. I'm looking at it, I guess I just went over her and stopped right there. Yeah. So I caused you to roll over and no. Yeah. And so then you flipped for a good amount. I was sliding. Is he good? I think a little bit better. Was good. Oh, I go home. I did, man. The 18 was looking like he shouldn't take off. No, he's not taking off. He's just chilling. He can't take off with the vehicle yet because this is part of our crash. Gotta stay, even with all the stuff he has in there.
Hold on a second. What's what about that?
The VIV is that thing. Oh, you'll go surprise her here. You hopefully. Yeah, I mean, this whole thing is yeah, it's why we get them to talk to y'all first and then if they're going away. I thought it might just give like a break. No, they like to do their interviews, especially when it's on scene. It's fresh, right? Yeah, if you just want to stay with them. We're gonna call through them type of the report. Y'all cool with watching them again?
All right, if you can go back, just back to the part. Where he says, talk to you first, then you can be on your way. Let me just rehear that, please.
Talk first and then think. Yeah, I mean, this whole thing, it's gorgeous. But, yeah, why don't we get them to talk with y'all first and then send y'all on your way? Cause I thought I'd just get like a brief statement, just be on my way. No, they like to do their interviews, especially when it's on scene. It's fresh, right? Yeah, if you just want to stay with them. You're gonna call them, we're gonna type up the report. Y'all cool with watching them again?
All right, so is that the end of his statement?
Yes, Judge, in this video, we have any other statements made by the defendant having to do because our body and set our office.
All right, so with regards to this video, defense, your objections will be overruled.
Thank you, Judge. And if I may, just real quick, I just said to the state, there's another timestamp that I think we might have missed, and it's 3:25. It starts at 3:25:45. And that's another example of him not being free to leave before that one, but we didn't get to see that one, Judge. We're going to see it now, hopefully.
This is 3:25:45.
Yeah, it's just look after that when you can hear the officer talking.
Oh, I think it's muted.
But it's muted.
Oh.
Yeah, and it is not loud.
It's not, but you can hear the officer there. On the, if I can proffer it, Judge, the officer is saying, Officer Morgan is talking to other officers, asking where the defendant is because he wants to know where he is. And then he tells the other officer, I think that's Officer...
Oh, no, you can remain seated, but...
I think he's telling Officer Chavarria, who we can see in the screen if it's not muted, where is he? He said he's getting picked up and tired of waiting. And Officer Morgan says, if we can hear it, I can't cut him loose. That is demonstrating his subjective intent to keep him there. And if he's keeping him there, he's detained. And if he's detained, our argument is, Judge, that he's under arrest.
All right, objection is overruled. With regards to State Exhibit number 2. All right, the jury's coming back in at 10:30. So if anyone wants to take a break, now's the time to take your break.
You can go outside.
You can go outside. All right, as they go and take a break, we're going to skip ahead. Okay, I think they came back right here. Let's see. Nope, not yet. Okay, he's back. Oh no, do we have audio issues? We have witness cam, but we need the audio to be turned on in court. Come on. Judge, don't do this to us. They're basically going to play that body cam footage. Let's see. Audio does come back. That's good. I'm checking it now. Let's see where it comes back. There it is. This one's on the judge, not on us. Sorry. So we're going to jump to when the audio comes back in this trial, which is right here.
And state, if you'll just, I believe where you left off, you were offering state's exhibit number 2?
Yes, sir.
All right. And any other objections you want me to hear before the jury comes in?
Yeah, Judge. I mean, I was going to say that we maintain or re-urge.
We are on the record.
Where is it? Why you got the Jack's video and stuff?
All right, defense.
Judge, yes, the objection to the video is the same.
And it's state's exhibit number 2?
It's 2, Judge. State's
Yes.
exhibit 2, which is, I believe, Officer Morgan's body camera. And they are to statements after 312. And it's the Zulu stamp at the top. It's not on the screen right now. It's 312, I believe it is. Our objections to any statement after that made by the defendant where he is not free to leave. He's expressed his desire to leave. His wife is there. He's asked if he can be excused and he'll give a statement. But the officer manifests his intent to keep him there. He's detained. He is not allowed to leave. He doesn't know he's not under arrest, but the effect of it, of the totality of the circumstances, is that his freedom of movement has been restricted in such a way that a normal person would believe that they are under arrest because he's not free to go and see his wife. He's not free to go to the bathroom. He's being kept there. So his the situation is the same as custodial arrest. And any statements he has made are because his will has been overborne by hours, not minutes, hours, 2, maybe 3 hours of questioning. And therefore we object to any of those statements that he makes after timestamp 312, I think it is, Judge. And the fifth.
All right, just 1 moment. State, are there any statements made by him after that with regards to this witness?
After the final statement that the state played for the hearing, there are no more statements. Anything else needed?
All right, the objection will be overruled. Let's bring the jurors in.
And Judge, just to that, I know, I'm sorry, and to any evidence after that, any statements by the defendant and any evidence derived from statements from him after that point, Judge.
So with regards to your objection, state has informed the court, and I watched state's exhibit number 2 with both state and defense, that with regards to this officer and this officer's body cam, there are no further statements through this officer after there is what appears to be a statement made by the accused about leaving. Is that correct?
Yes.
All right. Your objection is overruled. Let's bring in the jurors.
All right, for the jury.
If you will bring the jury.
All right, so a good fight on both body cam videos. He's objected on the same reasons, saying that he believes his client was technically under arrest, even though he was not arrested. And the judge overruled that.
All right, everyone, please be seated. And I believe where we left off, state you were offering into evidence state's exhibit number 2.
Yes, no, the state offers exhibit number 2.
And defense, your objections have been noted for the record.
Thank you, Judge.
All right, those objections will be overruled. State's exhibit number 2 is admitted. Granted.
Now they're going to play the body cam footage number 2, which we didn't get to hear the audio of before, so this is pretty good.
Well, I'm stopping your body cam at 156.11 in the top right corner. What are we seeing if you here?
I'm walking up to the what I presume would be the crash further north, but I couldn't make it with my patrol car.
And why couldn't you make it with your patrol car?
My patrol car couldn't fit through the sea of vehicles.
Just as we're watching the state's exhibit number 2, how many vehicles are out there on the highway?
I would say several dozen.
Now, fast forwarding all the way up to 156.29, what are we seeing at this, or 158.32, sorry about that. What are we seeing at this point?
The original crash I was dispatched to.
And what was the cause of the original crash?
Wrong way driver.
And who is the main handling officer on this crash?
I was the original handling officer.
Were you the only officer that showed up at the scene?
No, sir.
Who else showed up?
Officer Rodriguez and Officer Lechuga.
But you were the primary.
Yes, sir.
Can you explain to the jury, what does it mean when you're the primary?
When you're the primary officer, you're the one handling the report, taking statements, investigating what's happening.
Fast forwarding through state's exhibit number 2, did you speak to any of the witnesses that were involved in the crash, in that first car crash?
No witness.
Overall, you can answer yes or no, but do not state what anyone told you.
No,
So you didn't talk to anyone that was involved in the first crash, or you did?
I did.
Now, fast forwarding through state's exhibit number 2, up until roughly June 1737. Now, at this point, you've been at this first car crash for about 10 to 15 minutes, is that correct?
Yes, sir.
And at this point, now that you're back at your patrol car, what are you doing?
Making sure everyone has valid insurance and license.
So you're partway through your investigation.
Yes, sir.
Did you ever get an opportunity to finish your investigation?
No, sir.
What made you pause the investigation into the first crash?
I saw Officer Rodriguez and Officer Lechuga running towards my vehicle.
And when they got towards your vehicle, did they notify you of anything?
Yes.
And what were you notified of?
That they presumed I was involved in a crash, but they also heard a crash further south.
So they heard a crash further south. What did you do upon hearing that?
Went to go figure out what happened further south.
Now, fast forwarding, and this is to 2:23:30. What are we seeing here?
Talking with my cover officers about what happened.
And what are they informing you of?
That there was a crash that flipped. Or there was a vehicle that flipped.
And how far away from your patrol vehicle was this crash? I'm fast forwarding. Was it a close distance? Was it far?
It was pretty far from where the original crash was and where we were.
Is it 2:40 or 2:24:46? What are you doing?
Walking over to where they heard they had the crash.
At this point, at about 2:25:37, what are you beginning to do?
Starting to jog.
Bear with me.
To the vehicle.
And is the body
Sorry, I
worn
got
whenever you wear it? Is
pushing
it
the wrong
safe?
buttons.
No, never.
And what can sometimes happen?
It can shake.
And you proceeded about 2:26:14. Where's the body cam now?
It's in my hand.
And who are you talking to at 2:26:19?
I'm talking to Mr. Stefanov.
And who was Mr. Stefanov?
He was the driver of the Volkswagen, the first vehicle I saw.
And how many vehicles did you at first think were involved in this second crash?
I only presume that there was 3 vehicles involved.
What type of vehicles?
One was a Volkswagen, which Mr. Stefanov was driving. Then I saw an 18 big rig. And then I saw a Chevy Silverado.
So you first talked to Mr. Stefanov.
Yes, sir.
And Where was Mr. Stepanov's car in relation to that 18-wheeler?
It was about to its 1 o'clock.
Was it ahead of the 18-wheeler?
Yes.
And right here in 22633, where are you going now?
I'm running over to the Chevy Silverado.
And what do what's up in your mess? What's up, man? I'm okay. What happened? Yeah, because we have another accident over there. Yeah, I had my brakes and everybody talking. I couldn't fucking talk about. Oh, there's another car. Alright, I got you.
I'm stopping at about 22714. Who are you talking to at 22714?
Mr. Alexander Castro.
And do you see Mr. Castro here in the courtroom?
Yes, sir.
Can you point out to him and describe him by an article of clothing that he's wearing?
He's wearing the blue suit and gray pants.
I'll let the record reflect that the officer has identified the defendant. Where was Mr. Castro whenever you first encountered him?
He was in the driver's seat of the Chevy Silverado.
And did you ask him what happened?
Yes, sir.
And what did he say?
He said everyone's braking, tried to brake, couldn't brake.
And while you were talking to Mr. Castro, did you notice anything?
That he was involved in a very serious crash.
Did you notice any other cars?
Yes.
Well, where did you notice another car?
Further south of where his truck was, about it's 5 o'clock.
So further south. So it was further south on 281.
Yes, sir.
And so you were already responding to the first accident that's in Barrett County, but now we're going more south to where we're definitely in Barrett County.
Yes, sir.
Thank you, Al. But bear with me.
Now, 22720, what are you doing?
Running over to the Honda Accord because I didn't see a driver exit the vehicle.
Now, pause the video at 22755. How many people were in the Honda Accord when you approached?
Only one person.
What was the name of that individual? Did you ever gather that info?
Initially, no, but it was relayed as Miss Alexandria Sabert.
And what was Miss Sabert's condition?
She had a massive laceration on her forehead from what we could initially see.
Was she conscious?
She was not conscious.
While you were with her, did she ever regain consciousness?
Never.
Your Honor, may we approach very briefly?
Yes.
I'm eating my salad right now, sorry. It's mostly gone or I would show it to you.
All right, you may proceed.
I'm pausing the video at 22821. What are you trying to do here?
Trying to make contact with her, trying to talk to her.
And what's your concern at this time?
Making sure she's stable.
And were there other officers there with you while you were with Ms. Sabert?
Yes, sir.
Who else was with you?
Officer Rodriguez.
Did any other officers show up while you were there?
Later on, when I requested more, yes.
Fast forwarding. At 2:29:40. What are you doing here, sir?
Trying to alert other drivers that there's a major crash that just happened. Trying to get them to slow down.
And were all the other drivers slowing down?
Yes.
Fast forward to 2:30:37. At this point, Officer Morgan, what are you trying to do?
Still trying to make contact with Miss Cyber.
What does Officer Rodriguez do?
We're cutting the seatbelt.
Why are you cutting the seatbelt?
I believe that she may have been choking on her own blood based on the position she was in. So we wanted to put her in the recovery position.
What did you decide to do?
Extract her from the vehicle.
Was that the right decision?
No.
Why?
Based on my training, I should have just kept her there, wait for EMS.
Well, what was your concern?
My concern was making sure she wasn't choking on her own blood.
Fast forward to 2:31:50.
This is sad. The officer made a call and it was bad, and it could have contributed to the loss of life. That is terrible. And it may open up the department to civil suits as well. There's no audio here.
What are you doing at 2:32:35?
Making sure she's in the recovery position.
What's the recovery position?
Leg over leg. Making sure her head's stable.
And why would you put someone in the recovery position?
This way the blood does not go down their throat, can come out their mouth.
And did you stay with Ms. Seibert?
For brief moments.
I'm fast forwarding right now. Uh, 2:36:0. And I'm pausing at 2:36:04. Who did you meet with, Ms. Seibert?
I left Miss Cyber with Officer Chavadia and Officer Rodriguez.
And what was your concern?
Went to go make contact with the other drivers involved.
Was EMS already on the way?
Yes.
Okay. So, you got this one? Yeah. You got your license on you? Yeah. Yes, ma'am. Can you hear any hold on to the same location? As it's on you is correct? Everything was correct. What happened? Everybody hit the brakes on some of the brakes. I couldn't. I tried to, I hit the brakes and. Okay. Who'd you hit? You hit him? Nope.
Pausing at 2:37:10. So did you get another opportunity to talk to Mr. Castro?
Yes, sir.
And what did he tell you the second time that you spoke?
He said everyone hit the brakes. I hit the brakes.
And after that point, what did you begin to do?
Went over to Mr. Stefanov's vehicle after speaking with Mr. Martinez.
And Mr. Martinez, who was he? What vehicle was he driving?
He was driving the big rig for HEB.
And at 2:37:23, is that the big rig we see on screen?
Heb.
Yes, sir.
Fast forwarding now. Did EMS ever arrive?
Yes, sir.
Now we're seeing that here at 2:38:56.
Yes, sir.
So a few minutes after you encountered this cyber, EMS is here.
Yes, sir.
And are you aware, where did they take her?
Samsey, I believe.
In 2014, what are we seeing?
Me speaking with Mr. Stefanoff, trying to get his driver's license.
Speaking with all these other drivers, without saying what they told you, are you getting information on how the crash occurred?
Yes, sir.
We see at 2:40:46, we can kind of tell that Mr. Stepanoff's vehicle is ahead of that HV leader. Is that correct?
Yes, sir.
And where is Mr. Castro's vehicle in relation to that HV?
Right behind it, but behind the trailer.
And then the Cybert's vehicle, that's further south down 281.
Yes, sir.
I fast forwarded to 2:42:33. At this point, what are you doing?
Speaking with my cover officers, handing the original crash over to one of them, or asking them if they can handle that while I handle the fatality.
And what do we notice here? What's missing here that was there when you were further north on 281? What was there?
Traffic.
Where's the traffic now?
It's been moved.
Again, this time to about 2:44:29. Where are you now?
Inside my patrol vehicle,
And what are you doing?
contacting TID.
TID. Explain to the jury, what is that?
TID is abbreviation for Traffic Investigations Detail,
And what is TID's job?
to investigate severe crashes involving serious bodily injury and or death.
And why do you get to call them when there's cases involving serious bodily injury or death?
Because they're the specialists
What do they specialize in?
investigating how crashes occurred.
And so are you able to speak to a TID detective?
Yes.
Who do you speak to?
Back then it was Detective Martinez, now she's Sergeant Martinez.
And what are you doing when you're talking to Detective Martinez? Now Sergeant Martinez.
Telling her what the other drivers have said and in regards to how the crash happened.
And does Sergeant Martinez ever give you any orders as to what to do next?
Yes.
Object to hearsay, Judge.
All right, that'll be overruled. You can't say what was said. Just remember to answer the questions that's asked of you. So the answer to that question is either yes or no.
Yes.
Could you repeat your question, please?
Did Sergeant Martinez ever give you any orders?
Yes.
Did you follow those orders?
No.
What did you not do?
I forgot to call them back for an update on Miss Seibert's condition.
So after your conversation with TID, what do you think is going to happen next?
I'm under the presumption that they would be making our scene after they finished what crash scene they were on.
How long did it take TID to make that scene?
Roughly 3 hours and 20 minutes.
Did you ever follow up with TID during that time?
Not until after they asked me to call them.
While you were waiting for TID, or what you thought TID was on their way, what were you doing?
Repositioning my patrol vehicle.
Fast forwarding. Do 55. What are you doing at this point?
Making my way to the crash scene.
Now, where was your patrol vehicle originally?
It was on the exit ramp for Marshall Road.
Where are you now positioning your vehicle?
South of the original crash scene. I'm sorry, the secondary crash.
Okay. We considered number one.
We're going to get through this police body cam soon, and then we're going to get some better testimony instead of
What are we seeing in state considered number one? And this is at about 2:54:51.
An open exit ramp.
And what are you doing?
Driving to go take the turnaround at Marshall Road to go south.
Oh, at 2:55:15, what was the thing that we saw on that exit ramp? What did we see?
A tow truck towing a vehicle.
Was that one of the vehicles that was involved in the first car crash?
Yes.
I have these two paddles, yes and no paddles. I actually have two of each, but see, I hold them up like this, yes and no, so I don't have to interrupt or highlight.
Number one. What are we seeing on that fast forward?
Be driving south on the access road of 281.
We're watching body camera footage, which may not have any audio at all in court. There might be some, it's just not being picked up. But as soon as we're done with this, we'll get to more direct questioning and answers.
Now, what road are you turning on at 2:59:53?
That was the access road for North Loop 604 East. Now it looks like I'm about to take the entrance ramp before Redland Road.
At about 3:1:35, what are we seeing here?
I was shutting down the highway.
Why did they shut down the highway?
It's procedure whenever we're in TID's making scene.
And what exit are you passing here at 30159.
I'm passing up the TPC exit.
On the side of the road, are you noticing anything as you're driving towards where that second car crash happened?
There's no traffic on the access road.
Do you notice any signs?
Yes.
What are those signs for?
Construction.
So they're a warning.
Yes.
Construction zone. 90 and a 45 construction zone.
31, what are we seeing up ahead?
It's a terrible accident.
The second crash.
Could you see that where that second crash happened from a distance?
Yes, sir.
Now up ahead, what is that?
It's the second crash that occurred.
Now that 3303. After you repositioned your vehicle, what did you begin to do? And again, we're the state's playing state's exhibit number 2 at 3410.
Now I'm entering my patrol vehicle to write case cards for all parties involved.
What's the case card?
Case card is basically whenever there's an official TxDOT crash report or any kind of report that SAPD is going to be investigating.
So you have to give it to all the involved drivers?
Yes, sir.
That's 40. You see, exhibit number 2. I'm stopping at about 3940. What are we seeing as you're walking around it during state exhibit number 2?
The totality of the crash.
Just about ready to skip this. If he was on scene for 3 hours, we can't be watching 3 hours of body cam. Especially with no audio.
On 31020, who are you approaching?
Mr. Castro.
Oh, you're good. So it might be a good minute for you to be out here. We're waiting for our investigative unit to come out here. Talk with you to see what happened. That's for you. So at the top, it's going to be labeled as crash right now. Case number's right there for the insurance purposes. It's got all of you that's coming out of traffic investigation department. They'll come out here and ask you what happened. Do you recall what happened? Like, just traffic came to a stop?
I just remember everything came to a stop and I hit the brakes. And I just kept on the brakes and I kept seeing brake lights and everything just.
Do you know when you hit? Like, did you hit the 18 or
I thought I hit him, yeah. He said I hit him, but I don't know what I flipped on. I know I flipped.
You like rolled or like spun?
I know I rolled. I mean, you can see the scratches all sides.
Yeah, I can see the scratches. I guess if you just roll like that, try to figure out what you might. You know,
I think the 18 would have hit him, and he stopped all of a sudden, and I just stopped, like, just tried as hard as I could to hit the brakes.
Yeah. me to TPC, because that's the nearest exit. Because we can't have anyone coming through here right now. Your truck's stuck here for a little bit. I'm just wondering if my wife. Yeah, your wife wants to chill in the parking lot over there. That's yeah. Because like I said, it's gonna be a good minute, and we can always give you a courtesy right off the highway. You got any other questions?
Really just want to know what happened. All I know is everybody hit the brakes, and I hit the brakes, and I just couldn't stop.
Yeah.
They're all going with traffic, you know, I know more brake.
Well, I don't know if or not. I mean, I get told, I don't know how much experience they can do.
I have full coverage. I'm not worried about that. I'm just
trying to figure out what's going on. You and me both. So,
I'm stopping the video at 3:13:25. When you talk to Mr. Castro again, can you give any more details about what happened?
Yes.
What details did he give?
Said everyone's hitting the brakes. I hit the brakes. Couldn't stop.
Did he know what he hit?
He believed he hit the 18-wheeler.
Did he ever describe how traffic was flowing?
He said it was flowing as normal.
Now, after 3:13:26, I'm going to start fast forwarding. What do you begin to do?
Go and talk with Mrs. Stepanov.
I'm stopping the video at 3:14:37. What are you doing with Mr. Stepanov?
Trying to assess what injuries he has and let him know that EMS is on the way.
And do you talk again about what he may have seen?
Yes.
Now, fast forwarding. About 3:17:10. What are we seeing here?
Mrs. Stepanov's Volkswagen.
Forwarding again. About 3:18:51. What are we seeing you do here?
I'm talking to Mr. Martinez, gathering his information.
And are you also trying to ask what happened?
Yes, sir.
Fast forward again.
I think we're almost to the cross.
3:25:45. What are you beginning to do here?
I was trying to figure out where Mr. Castro went.
Was he in the same spot that he was in earlier?
No, sir.
Or where had he gone?
He had walked further south towards where my cover officers were shutting down traffic.
And did he stay with your cover officers?
Begrudgingly, yes.
Why do you say begrudgingly?
Because from what Officer Travaglio was saying, he was trying to be assertive and trying to leave.
Okay.
Fast forwarding.
I'm going to jump ahead just a tiny bit because this is killing me. We can't see any or hear anything.
What are you doing here?
Assessing the damage to Ms. Sabert's vehicle.
Officer Morgan, are you trained?
Involving a wrong-way driver, regardless of the injuries.
Okay.
In regards to this incident, sir, were you disciplined in versus that second crash involving Mr. Castro?
Yes, sir.
Was disciplined.
Yes. So can we approach now?
Yes.
Okay, we've got a quick approach here on this one. So the officer was disciplined for his actions on this crash, which he did make some mistakes in that may have gone against his training. Clearly, he's still an officer. You see him in uniform now, but he's being truthful about his testimony here. we're about to go back to. We're about to go to cross-examination. Down here. Still going. Whoops. That was too far.
Basically, I didn't.
There we go. Okay. Within 10 seconds or so. I think we skipped the rest of the break. I'm ready for the spiciness of the defense attorney who was already tangled with the judge a couple times.
All right, State, you may proceed.
Officer Morgan, did you ever detect any signs of intoxication from Mr. Castro?
No, sir.
Did you ever investigate into whether he could be intoxicated?
No, sir.
And was that one of the reasons why you were disciplined due to this secondary car accident?
Yes, sir.
What was the other reason why you were disciplined?
Alertness while working.
What does that mean?
Basically, I didn't have a sound and coherent mind while I was investigating.
Specifically, why did they allege that?
Because I failed to contact TID after calling them initially.
Now, you're standing by while Detective Martinez was talking to Mr. Castro. Did he ever admit anything while you were standing by?
I'm going to object to hearsay, Judge.
All right, to what Mr. Castro said?
Well, because it's coming, the answer to a question comes from a question and an answer that comes from a different officer, and that's where that answer.
All right, if you repeat your question.
Did Mr. Castro ever admit to anything while you were there?
Yes, sir.
What did he admit to?
He admitted to drinking beers.
Had you asked him anything about alcohol consumption leading up to that point?
No, sir.
Is that why you were disciplined?
Yes, sir.
That's the witness.
All right, here we go, defense.
Your cross.
Good afternoon, or good morning, officer.
Good morning, sir.
How are you doing?
Doing okay, sir.
Good. My name's Gary Hillier. I don't think we've met before. Is that right?
I'm sorry?
We haven't met before.
No, sir.
My name's Gary Hillier. I am one of the attorneys that represent Mr. Castro, and I have a few questions for you.
Yes, sir.
And I take it I have your permission to ask you questions.
Yes, sir.
Yeah, and I appreciate that. And I want to say before I start, there's no trick questions. If you don't understand something I'm saying, you want me to slow down, just let me know, okay?
Yes, sir.
All right. So, officer, you say that you've got, I think it's about approximately 5 years experience with the department now, is that right?
Yes, sir. With employment. Yes, sir. I've been employed with the city for over 5 years, but on the streets it's a little less.
Okay, but you've been employed by San Antonio Police Department for 5 years?
Yes, sir.
And did you have any prior law enforcement experience before that?
No, sir.
So it would be fair to say that, I guess it's 2024 now, you're in the academy at around 2019?
Yes, sir.
Is that right?
Yes.
And at the academy, I think you spoke earlier to the prosecutor about your training. You're trained on various things at the academy, right?
Yes, sir.
One of those is report writing.
Yes, sir.
And you taught stuff about the penal code.
Yes, sir.
Right. You're taught about to investigate scenes of crimes.
Yes,
to a certain extent, initially, right, as a patrol officer.
Get the groundwork going. Yes, sir.
Yeah, and in this case, we're talking about investigating a crash.
Yes, sir.
Right, because you know how to investigate. Get the groundwork going on an accident scene, right?
Yes, sir.
And you'd agree that all facts are important.
Yes, sir.
And I guess you'd agree with me that your report writing and the accuracy of your reports are important.
They are important, but usually my reports are summaries.
Yeah, there are summaries, right? I agree, because you can't write everything verbatim because it would be hundreds of pages long.
Yes, sir.
But it's important to put things in your report that matter to the investigation.
Yes, sir.
Because you rely on your reports.
I'm sorry?
You rely on your report, the accuracy of it.
Yes, sir.
Your supervisors rely on your reports.
Yes, sir.
And in this case, I guess, you know, we've spoken, the prosecutor spoke to you about it. Internal investigations, disciplinary people rely on your reports.
Yes, sir.
And today, this jury's relying on the accuracy of your reports, right?
Yes, sir. And body camera.
Yeah, because have you reviewed a copy of your report before today?
Yes, sir.
Have you got a copy in front of you now?
I do not, sir.
You don't. And you'd agree with me that it's important to write the totality of everything in your report?
I usually cover the basics, the important stuff. Yes, sir.
So you put, it's important, you think in the interest, is it important for your reports to be fair?
Yes, sir.
It is, right? Because that encompasses that totality. So what I mean by fair is you put evidence of innocence in there as well as guilt. Do you do that?
Yes, sir. I put everyone's statements in said reports.
But other evidence that you collect and observe, do you put that in there?
Yes, sir.
Because it's important in a case like this that you don't miss anything.
Yes, sir.
And you'd agree with me, there are policies and procedures on and your training that governs how you deal with scenes like this.
Yes, sir.
Right? And they come from the San Antonio Police Department manual.
Yes, sir. Our general manual.
The general manual. So the general manual is a public document, right?
Yes, sir.
And so I can access it. Anyone can access it on the internet.
Yes, sir.
And there is a document or a general policy that discusses how to investigate a crash scene, right?
Yes, sir.
And I'm not talking about how TID do it, traffic investigations. I'm talking about for a patrol person, right?
Yes, sir.
And do you remember what the specific number is?
I couldn't give you the specific rules and the general manual number, sir.
If I were to tell you it's 707, would you have reasons to doubt me? Can I approach very briefly?
Yes.
It sounds familiar, sir.
I'm going to show you.
And counsel, did you show the document to the state?
I will be judging in the market.
He says, I will. No, usually you show the state first.
Can I approach that?
Yes.
So I'm going to pass you the marked defense one. Do you recognise that?
Yes, sir.
Why do you recognise it?
It's part of our general manual.
Have you seen it before?
Yes, sir.
And in fact, did you get trained on this policy in the academy?
Briefly, yes, sir.
Briefly, but you recognise it. And would you kindly leaf through it for me, please, to see how many pages there are?
Five, sir.
Five, and is it substantially the same as it was when you were trained on it, to your recollection?
When I was trained on it, it looks like it was updated recently.
But that was the one that you were trained on, right?
2023, no, sir.
But that's the one sorry, that is the one that is that's the public document that is in force that controls now, right?
Yes, sir. It's been amended since I've been trained on it.
Okay. And it's not been altered in any way, to the best of your knowledge?
To the best of my knowledge, no, sir.
Okay. So I'm going to leave a copy of that with you right there. Because, I mean, you've been a patrol officer for how long? 5 years?
A little over 4, sir.
A little over 4. Sorry, you've been on the department for 5, patrol for 4.
Yes, sir, since 2019 of November.
Because what I want to talk about is your experience on the streets, right? Because I think that one of the things you said that you get called to scenes, is that right?
Yes, sir.
Generally. And so you'd agree that one of your responsibilities, not just talking about that document there, when you go to a scene, is to gather evidence.
Yes, sir.
And one of those, what that means is you've got to identify witnesses.
Yes, sir.
And usually procedure says that you kind of, once everyone's kept safe, keeping people safe is the first priority, right?
Yes, sir. Make sure there's no other dangerous to anyone else.
Yeah, and in a normal scene, if you go into a domestic violence scene, I guess that would be different to this, but you separate the parties and keep them safe.
As best as we can with what we have.
Best as you can with what you have, exactly, because you're only human, right?
Yes, sir.
And we all make mistakes from time to time.
Yes, sir.
And like you've been very honest with the jury, you've made mistakes in this case, right?
Yes, sir.
And we appreciate your candor, officer, we do. But everything you do and you're trained to do is for a reason, right?
Yes, sir.
And separating witnesses is so that you can speak to the first witness or however many witnesses are away from the second one.
As best as we can, yes, sir.
As best that you can. Like in an ideal word, you separate the parties so you can say, hey, can you tell me what happened, please? Okay. Without this person interjecting.
The defense counsel testifying.
Sustained.
So you separate witnesses.
As best as we can, yes, sir.
And the reason you do that is that they don't talk to each other.
Yes, sir.
And they don't infect each other's version of events.
Yes, sir.
So they don't say to each other, tell people stuff that happened to add facts into their knowledge.
Yes, sir.
So that witness 1 isn't influenced by something witness 2 says.
That'd be correct, sir. Yes,
yeah,
sir.
and you'd agree that in this scene, you were here for some, how long were you at this scene?
With all parties involved, sir?
Yeah, with all, how long do you think? It was hours, right?
Total video, including the first crash, is about 7 hours.
Yes, hours and hours. Whoa. So you were there for a long time. So you weren't the only officer there.
No, sir.
There were several officers there.
Yes, sir.
And everyone's got the same training.
Yes, sir.
Because the point I'm trying to make here is that you're trying to separate witnesses, but it's difficult.
Yes, sir.
And sometimes witnesses, in a scene like this, they're walking around, they're talking to each other.
Yes, sir.
So it might not surprise you that that a witness might say something at the beginning when you speak to them. They give you a version of events at the beginning, and then hours later, when they've been talking to other witnesses and other officers, they might add things in.
It's a possibility, yes, sir.
Because that's what happened here, right?
I wouldn't know, sir.
Do you remember Mr. Castro, when you first spoke to him, he said some things about what happened, and then later on he said, well, the officer told me that it was a woman. I didn't know that before. Do you remember that bit?
I don't remember that, sir.
We can talk about that in a second. But I want to talk to you about your first involvement in this case. You told the prosecutor that you were called to your original call was for a wrong-way driver.
It was for a major accident involving a wrong-way driver, yes, sir.
And do you know who Shayna Alassal is?
She was the wrong-way driver.
She was a wrong-way driver. And do you remember speaking to her?
Yes, sir.
Now, you spent a short amount of time with Miss Alassal. Is that fair to say?
Yes, sir.
But when you made your way to the scene, you had to drive through backed up traffic, correct?
I had to walk back, yes, sir.
So there you go. So you had to drive to the scene. We'll look at the body camera in a minute. You drove to the scene as far as you could, but you were driving, is it Northam 281?
Yes, sir.
So you made your way, you were the first officer to respond, is that right?
We were all pretty much in close proximity of each other when we were arriving.
So dispatch, a call comes in and dispatch calls local officers and then they go, is that how it works?
Correct. They sent Officer Rodriguez and Officer Lechuga first, but since it was my square, I got off my break to go handle the call.
So, all right then, so it was your square. So by your square, are you talking about your patrol square?
Yes, sir, for the night.
Yeah, your district where you are assigned that square of territory, that's your space for the night to patrol.
It's not my specific space, but that's the one where I'm usually the primary officer. I still can respond to anywhere in the north side, and if there's a critical incident, we can go anywhere in the city.
Right, so of course, but that's you're the primary for that area. So you're the first one to get there.
Roughly, yes, sir.
Roughly. I mean, it was Officer Lechuga and Rodriguez.
Yes, sir. They were right behind.
They're kind of behind you. They arrived soon after.
Yes, sir.
Right, but was that State's Exhibit? Can we? Can I look at States too?
Yeah.
Yeah. So what I want to do is we've got some technical difficulties here. I want to try and this is your body camera, right?
Yes, sir.
Please been admitted into evidence of states. So this is, have you got your camera on you today?
No, sir. It's charging at the station.
Right, so you don't have to wear it to court, but you have it on your body and it's recorded when you have an interaction with the public, right?
If it's the same one that we had back then, yes, sir, because we've recently got new ones.
But it's on your body and it records everything that's happening.
Yes, sir.
So what we're going to see is you've arrived at the scene. Right.
From the map, it kind of looks like it, but it looks like I'm still on the way.
I'm sorry, I'm not in control of this, but right, okay, this is you arriving at the scene, fair enough?
Yes, sir.
So can you pause it now? So you've been called to a major accident where a person was a wrong-way driver, your testimony, driving up the access road onto 281.
Main lane, sir.
Onto what, sorry?
I was driving on the main lanes and it forces everyone onto the access road.
What, mainland?
Main lanes. I apologize. The freeway. Yes, sir.
So, but she's coming, if we can see the screen at the top there, in the top right-hand corner, this is kind of 281 traveling north, right?
Yes, sir.
And so what we're seeing now is the traffic. You can't take your vehicle any further, right?
No, sir.
Because although we can't see it, the traffic here is kind of 2 lanes, but it's going to go down to 1, right?
Further down, yes, sir.
Further down, right? And then it goes from 2 lanes, which it is here, you can see on the screen, right?
Yes, sir.
And then it's going to go into 1, right?
Yes, sir.
And then that 1 is going to go off the exit ramp.
Yes, sir.
And that's where the wrong way driver has come up and had a collision.
Correct. They came from the access road.
Sorry.
They came from the access road.
They came from the access road. Obviously, the wrong way on the access road, come the wrong way up the access of the exit ramp, right? They're driving the wrong way on the highway. Right, okay. So this is where, at this point, you parked your vehicle at the back of the traffic that's backed up.
Yes, sir.
Correct. And if we see the top right-hand corner of you see the yellow triangle, it's really weird doing it from here, I'm sorry, officer. There's a time up there, there's a timestamp. You'd agree with me on that, right?
Yes, sir.
It says axon body 3, then there's an X and some numbers, and above it there's the date, right?
Yes, sir.
2022, 7/22, and 0156, it's written in military timing, is that right?
Yes, sir.
And that basically tells us what time it is. So you're arriving there at 1:56 a.m. and 9 seconds, I think.
Yes, sir.
Right, okay. And so this is as far as the traffic's up. So now, what we're going to look at here is we're going to see you, if you bear with us, you're walking down now through several vehicles that are already piled up, right? The traffic is piled up. Would you agree with that?
Yes, sir.
I mean, and that's as close as you can get in your car, right?
Yes, sir. At least from where we came from.
Yeah, and so because now here we see that the traffic is trying to go over to 2 lanes, and the traffic is already backed up, and you see reverse lights. People are moving their vehicles, right? They can't go anywhere, but you are approaching the accident scene for the first scene.
Yes, sir.
You said you were the handling officer.
Yes, sir. Initially.
So what does the handling officer mean, officer? What does it mean to be the handling officer?
Basically, the one that's going to be writing the report.
So because you're first on scene, or because it's your square?
Either or.
So it would be fair to say you get there first, and you speak to Mr. Lassell.
Yes, sir.
And then your other colleagues come and help you.
Yes, sir.
We might see them come and help you in a second. So you make an initial assessment of her, right?
Yes, sir.
And I believe I was kind of unsure with the testimony earlier. Did you speak to Mr. Lassell?
Yes, sir.
Did you spend much time with her?
Not much time, sir. No.
So your interaction with her was kind of brief, right?
Yes, sir.
And they're not trick questions, officer. And you'd agree with me that the people who really spent time with her were officers who agreed as an officer would shoot them.
Yes, sir.
Because you keep what I'm saying, what we're seeing is how many vehicles already you have to walk past to go down to this C, the first C, the wrong way driver.
Yes, sir.
Have you counted how many vehicles it is?
No, sir.
How far do you think it was?
Maybe around 200 meters.
200 meters worth of vehicles end on end.
Yes, sir.
So video still shows you walking down there. Because what does the policy tell you? What does your training tell you that you should be thinking about right now when you're approaching a major accident?
I'm trying to figure out where the crash is.
Right. Okay. So you obviously have to, because you said this came in as a major accident.
Yes, sir.
One of the things you're supposed to do is call TID anyway, regardless of the casualties, right?
Yes, sir.
So you said that one of the things you're supposed to be thinking about is identifying where it is.
Yes, sir.
And then what does the policy tell you? What does your training tell you about once you've identified the scene, what you're supposed to do there?
Speak to witnesses and try to clear up the roadway.
And here we are, we've identified. So speak to witnesses and try and clear up the roadway. And like we talked about witnesses, you identify them. I guess you deal with casualties as best you can.
Yes, sir.
And I'm talking about this one first that's on the screen. This is Miss that's Miss Alassal's car.
Hold tight. I just messed this up. I'm trying to get the timestamp of where we're at on this. And I just backed out completely of it. It's one of those days. I should have got more sleep last night. Judge Stephanie Boyd. Okay. There we go. We're almost done with this testimony, and then they break for lunch. Just 1 second here.
Yes, sir.
I'll read a paragraph 4 then. Any casualties?
Yes, sir.
And this is according to that policy that you've identified, right?
Yes, sir.
And then you said, did you say something about clearing up the roadway?
As best as we can. Yes,
and I guess by that you mean that can mean a lot of things, right? That can mean clearing up debris off the road.
Yes, sir.
Yeah, because there might be damaged bits of car that you've got to get out of the road that are going to cause damage.
It depends on the kind of crash that we have.
It depends on the kind of crash.
Okay, this is today. This is today's trial.
You'd agree with me that clearing up the roadway means providing notice to other drivers, right?
As best as we can, yes, sir.
As best you can. And in fact, that policy says that's the first priority, right?
I believe so, sir.
Well, according to your training, I mean, review it if you want. You can please take a look. Can I approach, Judge?
Yes.
You do it? Oh, it's just no, I don't need to, Judge. We've got the same. He's already got a copy. So, also have a look at the first. I'm going to approach. Sorry, Judge. It might be easier. The bottom paragraph, responding to crashes. I've got colour. I'm sorry, I've got the colour copy right. Take a look at paragraph 4.
Yes, sir.
I'll read paragraph 4 then.
Yes, sir.
Because the policy is it's the guidelines and training for dealing with accidents, right? Yep.
I'm sorry, sir?
The policy's, it's designed, it's what you're given in the academy. Like I said, it's a public document.
Yes, sir.
It's designed to help you investigate, a guide for investigating accidents.
Yes, sir.
And you agree that when it says responding to crashes, the first officer arriving at the scene is you, right?
Yes, sir.
So the first officer's responsibilities are to warn of the crash to approaching vehicles.
Yes, sir.
As best you can, right? Because you're a human being.
Yes, sir.
But you'd agree with me that that's what that policy says. The first officer responding, their job is to warn other motorists.
Yes, sir.
As best they can. What ways do you, and we've seen them, the prosecutor showed you the video, earlier, we said, what do we see now that we don't see? What ways have you got at your disposal to warn other motorists of accidents?
We have our red and blues, we have our directional arrows, and then we also have flares.
So when you say your red and blues, what you're saying to the jury is you're talking about the emergency lights that go on top of the cars.
Yes, sir.
Right, and all patrol vehicles have them.
On top, most of them.
Most, I mean, maybe some don't, right? But most cars on patrol have. So there are other vehicles coming to your scene, right, with emergency lights, the red and blues.
Yes, sir.
Okay. And there's flares.
Yes, sir.
And do you have flares on board your vehicle?
Yes, sir.
Is it standard issue for people to have flares?
Yes, sir.
You know, patrol officers.
Yes, sir.
That's the standard kit in every vehicle. And what else do you have that you can put on?
A reflective vest.
Reflective, is that what they call a reflective vest? And what is the point of that?
To ensure that we're on the roadway, and if we get hit, city will cover us.
Yeah, okay, it probably is it, right? So that the city will cover you if you're insured if you get hit. But you'd agree with me, it's also to warn people because they're reflective, and if lights hit them, it kind of says police and stuff, right? That's the other ways to warn, right?
Yes, so that there's a pedestrian there.
Yeah, and this isn't a criticism, but you'd agree with me that you went to that scene, you're the first one there, but no one ever did anything to warn the vehicles behind you.
We had our red and blues on.
You had your red and blues on, but let's go back over very briefly, have a look at that body camera again. Can we, Dan? You had your red and blues on. So do you remember what time this call came in? It doesn't matter if you don't know roughly.
The first crash?
The first crash.
155.
155. So it's taking you a minute to get there. It's 156 now. Is that right?
Yes, sir.
So it's taking you 1 minute to get there. If we're going to get out your car, this is from 1 minute, right? You've got your red and blue flashes on. You're the first one responding. So your priority is to go to the scene.
Yes, sir.
And your priority is to make sure no one's injured at that first scene right now.
Yes, sir.
Okay, and we can see the build up in 1 minute. I didn't count them, but you've gone through 200 meters worth of traffic.
Yes, sir.
So for every minute, I mean, I'm not asking you to commit to this, but for every minute that you spend at that first accident, what's going on behind you? Because what road are you on there?
The exit ramp from Marshall Road.
But what highway is that?
281.
It's a highway.
Yes, sir.
Right, and there's people traveling on it.
Yes, sir.
So for every minute you spend at that accident, what's happening behind you?
Traffic's building up.
Traffic's building up. It's building up every minute. So you've got this call came at 155, at 156, there's 200. I think that makes a point there. So in 1 minute, just to your estimation, because you were there, there's 200 meters worth of traffic built up.
Yes, sir.
I'm not asking you to do any math. I'm not going to ask you to do any math. I'm bad at math, right? But you'd agree with me. You were it was around 2:20 when the second incident happened.
Yes, sir.
Right, and that's around 23 minutes after you first got there.
Yes, sir.
Right, and so you arrived on scene at the first accident within a minute, and there was 200 meters worth of traffic.
Yes, sir.
Right. So after 23 minutes on scene, what was going on behind your car?
The second crash happened?
But where did it happen?
Further southwest.
Further south. Approximately how further south?
I would say maybe 200 meters. I'm not an expert.
Probably a bit more than that, right?
Yes, sir.
Yeah, probably quite a bit more than 200 meters off the right.
Yes, I didn't measure whenever I went there.
Yeah, because you had to walk and then you could run. We'll have a look on the video in a minute, but it was quite a distance.
Yes, sir.
Right. And I know that what you wrote in your report and that you noted in your report that you noted in you have a copy of your report in front of you?
Not with me right now, sir.
Reviewed it today?
I haven't reviewed it today, sir.
Yeah.
My report.
No, I'm just going to get a clean copy.
No, I have a report.
Excuse me, everyone. This is what I want everybody to do. Court reporter cannot hear Everybody needs to stop whispering. Everybody needs to speak up so the court reporter can hear and so that the jury can hear. So ask your question.
Sorry, Judge, I can't remember what I was going to say.
Do you have your report?
Not with me, Your Honor.
He does not have his report with him.
Would it help if you had a look at it
Yes, sir.
to refresh your memory? I'm just going to shut that. Right.
We're gonna break for lunch here within the next 30
Yes,
minutes,
sir.
even if the judge doesn't. I think we're
Is that your
almost
report?
done
Sorry, I've got to speak up.
with the morning
Yes, sir.
session.
All right. So we're looking at this front page here has got some like biographical data on the top, time, place, and where this happened.
The approximate location, yes, sir.
Yeah, and the bottom part. And I'm sorry to reach over you, so the bottom bit's called the narrative.
Yes, sir.
Right, like you said earlier, this is a summary of what's going on.
Yes, sir.
Because you can't write everything.
Yes, sir.
But these are your main thoughts and recollection. Did you write this when this incident was fresh in your mind?
Yes, sir.
And did you write this before you go off duty that day?
Yes, sir.
And is that your policy?
Yes, sir.
Yeah, okay. And it details, I want to draw your attention to page 2 if you'll turn over. It's the second paragraph. Right. I want you to read that and then look up. That's the second one. Yeah. And can you have a look at the third paragraph, the last couple of sentences of the third?
Counsel, you want to mark that so that the record can be clear?
Just mark it as defense 2. Let me go get a sticker. I'm not going to enter it, Judge.
I understand.
We'll mark that document as defense 2. Yeah, just draw your attention to page 2 and I'll have it down there. So you agree that your perceptions of this incident, by the time you went to the second crash with Miss Siebert, there was a lot of traffic lined up on the highway.
Yes, sir.
Now you would agree with me that nobody from SAPD went to the back of the traffic to try and close the road at that point.
After the first crash or the second crash?
Well, after the first crash, your vehicle was there.
Yes, sir.
With your red and blue flashes on, right?
Yes, sir.
What do you call them? Not red and blue flashes. What are they called?
Emergency lights.
Emergency lights. You had your emergency lights on. But then you have walked 200 meters down to the scene with Mr. Lassell.
Yes,
Right.
sir. I wasn't aware exactly where the crash happened.
No, I'm not saying you should be, but you've gone and located it and you've seen that there were no casualties and you've spoken to the drivers very briefly.
Yes, sir.
Right. But then your colleagues come and you leave her, Mr. Lassell, and the other parties to deal with that while you go and start writing your report.
That and to make sure everyone had valid licenses.
Yeah, and you're doing your investigation, right? And that's what you're supposed to be doing. But then you go and sit in your car and you're in your car for 20 minutes and nobody from the San Antonio Police Department thinks, hey, hold on a minute. You've been sitting here for 20 minutes. Let's warn the drivers behind you because traffic's backing up.
Sustained.
But let's look at the video. Let's look at your body cam.
All right, let's pause here. Ladies and gentlemen, I'm going to give you all your lunch break. We're going to come back at 1:30 and we're going to continue with testimony. Remember my instructions. Do not think about this case outside of this courtroom. Do not do any investigation. Do not view anything. Do not talk to each other. Does everyone understand?
Don't even breathe.
Well, when I say do not talk to each other, I mean about the case. All right. All right. If you can meet us, please, and we can go off record. There are many.
She muted. I think she's talking about places to eat. That's it. There are many places to go and eat. She's telling them what they can do on lunch, where they can get food. Okay, so that's all good. All right, we're going to go in. They're calling it quits here for lunch break. We're going to take a break as well. we'll be back after lunch with the second half. I think it will get spicier. Just to give you a little quick tease about what happened before for those who missed this. I think I've queued this up to the right spot. Let me jump back in time.
Please follow the law, because the first domino in this case.
Let's see.
Is Shayna Lassell. She's not here. She was driven home by the police after driving drunk the wrong way down the highway. The second domino in this case is the police failing to warn anyone. And the third one is the only one that they've got. He's sitting here, is Alex Castro, and he's not negligent. He's not reckless. If anything, he's negligent.
Sustained.
I'm going to ask you to find him not guilty. Thank you.
Right, thank you. All right, ladies and gentlemen.
Man, I missed the part where I thought, where's the judge talking? No. I've got to find it. Okay, we missed it. I'll find it again. But he got a little snarky with the judge and went back and forth a little bit. I've got it recorded. I thought I had the right one, but that was the wrong objection. Started saying, the defense was saying, we object, and he said, they're objecting because they know I'm right. And the judge was not having that. So, looking for it. I don't see it. There it is. Maybe right here. Let me try this one. Hang on.
But he disregards it. So saying that he's driving, the state's just said in opening that he's approximately driving 90 miles an hour. He's driving too fast the right way down the highway. So if he's disregarded the risk that he knows is ahead, remember, they've got to prove, and you swore an oath a minute ago. The judge gave you the oath. You swore to follow the law and the evidence. This is the last thing I'm going to leave you with. If you follow that oath, you've got to swear to follow the oath, to look at the law, which is that Alex Castro was aware of a risk,
it's the weirdest
and he
opening
consciously
ever.
Disregarded it. It doesn't make any sense, because you're saying, this prosecutor's saying he's doing 90 miles an hour and he's driving into a brick wall, because that's what they're saying. That's what recklessness is in this case. He is driving 90 miles an hour, according to the prosecutor, into a brick wall. That can't be the case. It makes no sense, because that means that's suicide. That's tantamount to him trying to kill himself. Common sense says that. If you are driving at the speed Mr. Escobar says he is, and you're driving into parked traffic, you're trying to kill yourself.
Sustained.
You're trying to kill yourself.
Sustained.
And that defies common sense. You see, I'm right. That's why he's objecting.
All right. All right, number one.
Okay, so
the objection is sustained.
So yeah, so it got a little spicy there at the beginning. I think we're going to see more of it. Anyway, so we're going to go to lunch. We're going to take probably about 45 minutes, and we'll be back with the second half. This is today's trial out of Bexar County, Texas, with our one and only Judge Stephanie Boyd. We're super excited for this. It is a car crash, an accusation of DUI that's disputed by the defendant. He's saying he drank earlier before, and that's what he was talking about. The investigation was sort of bungled. We heard that from the officer. He sort of messed it up a little bit. But we'll get into more of this after lunch. We're going to take a little bit of break. I know it's late in the day, but we're going to do that. I might lay down just for a minute and rest my eyelids during lunch, because it was a late night last night. But the verdict came in so late. Oh my goodness, I've never seen it happen like that. But it was wonderful. You guys, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe. So we'll go live again in about 45 minutes, roughly. We'll be back for the second part of day one of the Texas v. Alexander Castro trial. Oh, okay. There we go. I had my salad already. I'm good. But a little bit of a break, a little bit of a rest. I'll be back ready to go for part two. And we'll see if we get some more fireworks out of this one. You guys have yourselves a fantastic lunch. We'll see you in just a little bit. Bye-bye.
If they didn't, I would lose my mind.
Shame on you, sir.
I saw a chicken fight.
I think I'm about to catch a whooping.
Because he's the guy.